entire world could be watching right now. Okay, just for information purposes, my two cell phones each agree that it's 9:53 a.m. My computer says 9:55. Let me see if I can change that. I'm not sure this state government IT allows me to change that. I think they don't. I'm not allowed to change the time. So I'm going to go by 9:53. We've got about 7 minutes before the scheduled beginning of this hearing.
Mr. Hearing Examiner?
Yes, good morning, Ms. Stevens. Good to see you.
Hey, good. I realize my sound is really loud. I'll just have to. Miss LaRock is having difficulty getting in. It says, she says that it's telling her she needs the passcode. I didn't when I used your URL. And she's texting me back and forth with Phil Simpson, who I don't see on your list.
I see Mr. Simpson there. Hold on just a second. Anna, yes? Yeah, Miss Stevens just told me that. There's no passcode needed, but I can, it just isn't. But I will go to the Zoom page and see if I can find what the password is. It's on the invitation, which I sent to everyone. All right, well, let me try to straighten that out.
Mr. Lennon, I know that
Thanks,
Lisa
Anna.
and I were trying to use just the URL that was in the order.
Right? And that worked for you?
That worked for me, but not for her, oddly.
Well, it's worked for
everybody
quite
else.
a few people, so I suspect that
maybe it's a problem with her settings.
Good morning. If I may, I also had that same problem.
And how did you resolve it?
Well, I switched from my iPad to my PC, which limits my ability to view documents while we're talking, but it is what it is.
I sent her a message.
Yeah, we're PC based here, not Apple. So yeah, that could be the problem. But well, we've got we're supposed to start this hearing right about now. So I'm going to, out of respect for everybody that's here and logged in, I'm going to let her try to resolve it on her own.
And should she be working with Anna, or who should she be trying to go to for help?
Hold on just a second. I mean, I sympathize, so I wanted to.
Yeah, she's.
Once again, I'll look on my information on this end.
Did you actually send an invitation?
You mean a Zoom invitation?
A Zoom type invitation.
Yeah, I usually send that by email to the lawyers, and I tell the lawyers to circulate it to any witnesses.
Yeah, let me look for. Allow me to look for that, because I sent her the order.
I just shared it in the chat. The Zoom link we were all sent. Maybe you want to reshare that with her.
Well, I think she's not getting in at all, but
I'm just wondering if she has a faulty link.
See whether.
Well, at the beginning of the hearing, I need just counsel, actually. And then we're going to need the first witness.
That's true.
Well,
I'd like her at least to be on when I guess she could watch on Zoom, but when the other witnesses are going.
Right.
Let me just, if I could, was there a, I don't remember.
Our witness decided that he would access the hearing via YouTube and thought it was protocol that only when he was called that he would be brought into the Zoom.
Well, for witnesses, that's fine. And Ms. Lynch, hi, good morning. Sorry.
Oh, I have, no, that's. I try to say, Mr. Lennon, I try to save and rescue them from deleted mail, all these invitations, because I need much in the way of redundancy to get into these things. And I'm not seeing one in this case, but maybe it's in the.
Yeah, I'm kind of digging for it myself, but it shouldn't be.
Let's see, maybe the supplemental procedural order.
It would be the date of the procedural order, the supplemental procedural order.
Let me check which one I sent her. Here's, I think I might have sent her the.
Here is Lisa LaRoque.
Supplemental order. Sent.
I just texted her the link, and I think that's going to work for her. The link that somebody shared.
There is a Lisa LaRoque that's on, but her screen is
Oh.
up and
Well,
she's muted.
that's good. We're making progress. Now, new link worked. Her text messages, new link worked. So we're good.
Absolutely.
Now that she's on, are you going to insist that she be off because she's a witness and should just be on?
No,
YouTube?
not really. You know,
Or we
it's
stick with the good
optional.
thing?
I definitely want to be unmuted. Interestingly, I don't know how other people do it, but I really like the picture, the video to be on, even though I like the audio to be off. Hey, we've got a nice little child there with Mr. Elliott. Or is Mr. Elliott the smaller person or the larger person? He's both.
Mr. Elliott's.
Excellent, excellent. Well, anyhow, I like to have the video on because it feels more like an actual hearing, and I think that behooves us all. It's just better. But I do like the audio to be off so we don't hear dogs barking and eggs being cooked on the kitchen stove and that kind of a thing. So as for the Zoom protocol, please leave your video on, but leave your audio off. Video sometimes helps me because I see somebody talking, but I don't hear them and have to remind them to turn off their mute, or I'll see somebody objecting and they'll do it by raising their hand. And they, I realize that I'm not hearing the objection or that they're actually objecting. Anyhow, there's Miss LaRoque. How are you, ma'am?
I'm muted. Very well, thank you.
Well, you're not muted now, but thank you. I'm glad to see you. And there's Mr. Black with the PRC staff. And there's Mr. Dunn, who gets the award for logging on at 9 o'clock in the morning. Welcome, Mr. Dunn.
Classic overachiever. Thank you, Mr. Hearing Examiner.
Okay, I think we have all parties and even a whole bunch of witnesses. So it is now on the satellite clock, says 10:06. We are actually starting 6 minutes late, which is not a substantial issue or a problem. Mr. Lee, I would appreciate it if we remain off the record until I say we'll go on the record with your permission. Is that okay, Mr. Lee?
Certainly.
Okay, and there's a few other matters. Mr. Lee likes to take a break at least once an hour. And Mr. Lee, do you like 10 minutes an hour?
If possible, and perhaps hour and a half mark.
Perhaps you what?
The hour and a half mark.
Hour and a half. Okay, well, that's better. Honestly, sometimes I get rolling and I forget to watch the time. Usually counsel or some other person will remind me. And I like to stop only at opportune moments. So I'm not going to interrupt testimony. There's going to be a break at the conclusion of someone's testimony or the cross-examination more typically. So that's how that works. We're beginning at 10, which is not 9 or 8, obviously. But I think we should also consider taking a lunch break, say about, I don't know, 1:30 or 2 o'clock. Does anybody have an opinion about that? I know some people have to eat for medical reasons and that kind of thing. Well, let's just plan on, is 1 acceptable to everyone? Okay, I get some nodding heads. That's good. That's one reason I keep the video on. We'll plan on 1. We'll end somewhere around there, 15 minutes before, 15 minutes after, whatever, depending on the witnesses. Somebody's checking out, in or out. It's Mr. Simpson. You're probably switching to your telephone, right, Mr. Simpson? Okay, that could work. Mr. Simpson, now I've got 2 of you. That's really scary. I can watch in stereo, but I have to wear special glasses. All right, I also want to remind everybody that we are on YouTube. So that even means people that are not lawyers or witnesses are watching this proceeding, and they may be wondering about the informality so far. Well, actually, we haven't started the proceeding yet. I want to go, I don't see any reason to have certain things transcribed on the official record. And that's why I'm going through them before we begin the official record, but it is part of the proceeding. So what I'd like to know, I usually ask the movement or the applicant to present their witnesses first, which is, of course, is El Paso Electric. Miss Olson, you're here, aren't you? There you are. Thank you. Are there any, good morning. Are there any other attorneys going to be co-counsel with you on this hearing?
I do have Mr. Wexler in the room with me, but he isn't intending to present any witnesses or do any cross-examination unless I get hit by a bus, I guess.
Okay, well, I actually understand exactly what you mean. Having been hit by many buses in my careers with an S. You're going to present Miss Burns, well, I'm not going to, excuse me, not Miss Burns. You have Miss Perea, Miss Martin, and Mr. Hernandez. Is that correct?
That's correct. Those are our 3 witnesses.
And is that the order of your presentation?
Yes, that's our intention. Perea, Martin, and then Mr. Hernandez will go last.
Okay. You have no other witnesses, correct?
That's correct.
All right. Well, I don't really know, but that might take us up to lunchtime. I really have no way of actually knowing how much cross-examination there's going to be. The next gets a little fuzzier on who goes first. The city of Las Cruces is pretty active and has 2 witnesses. Ms. Stevens, do you have a opinion about the order of the next parties? You want to go next?
Mr. Lennon, first of all, I don't know whether you want to do it on the record or off, but we do want to raise the question of Ms. LaRock adopting Mr. Provencio's testimony, because I actually didn't check in with him this morning. I was so bad, but he went to his orthopedist yesterday, and I'm sure he's not a happy camper right now. No, we would like to substitute and have Ms. LaRock sponsor both pieces of testimony.
Well, I saw
So we'll
that.
just have, if you consent to that, and as I say, I don't really have an alternative, we'll have 1 witness, so we won't have an order of witnesses.
Well, as you know, the person who, the witness is supposed to appear and be subject to cross-examination.
Yeah.
So the question isn't whether I order it or grant your motion. The question is whether there is an objection really to Ms. LaRock testifying, or rather standing in the place of your injured witness. So let's go around the table here and see if there's an objection to it. And if there's no objection, obviously that I would grant that motion, calling it a motion. So let's ask Mr. Black, do you have any objection?
No, no position, Your Honor.
No position. All right. Mr. Elliott, do you have a position?
No, Your Honor.
Do you have an objection?
I have no objection.
I guess the question is whether you can elicit the testimony on cross-examination from Mr. LaRoque that you would be able to elicit from the injured witness. And, I have actually read the testimony. I do not know how familiar Ms. LaRoque is with the testimony of her coworker. I'll just throw a couple comments out there. I do believe that testimony from a witness who is subject to cross-examination is more valuable than from a witness who is not subject to cross-examination. And, that's a general rule, not just for this case. So, and, it's up to counsel to present the strongest case. And I understand there's always problems, and, this is the strongest case that can be presented by the city of Las Cruces. That's just fine. I don't have a problem with that. Mr. Simpson, do you have any objection to Ms. LaRoque standing in for the other witness?
No objection, Your Honor.
Okay. Who are we missing?
Ms. Olson.
Ms. Olson, did you opine on it? What's your opinion?
Yeah, hearing examiner Lennon, we had the initial same concerns that you did. Mr. Provencio appeared to be the city's witness testifying to contested issues. And so that was our concern when Ms. Stevens approached us about waiving cross-examination, and we said we weren't willing to do that for that reason. Ms. Stevens then proposed the alternative solution of Ms. LaRoque adopting that testimony and standing for cross-examination as the city's witness on those issues. And I believe that resolves our concern of not having the ability to cross-examine, and so therefore we don't object.
Okay, I think we've covered everybody. Ms. Stevens, you still there? All right, I'm going to allow her to stand in for Mr. Provencio. I hope he gets better. But I want to, just mention that, like I just said, this testimony would probably be stronger if he had appeared and been subject to cross-examination for his testimony. We roll with what we've got. We'll go with what we've got. And Ms. Stevens, if that's how you'd like to proceed, there being a few comments, but no exact objection, you're welcome to present Mr. LaRoque and have her establish the foundation for the admission of Mr. Provencio's testimony, and then be subject to cross-examination. All right, that's one thing finished. Where were we? We were talking about some things that I really didn't think needed to be on the record. Basically,
We didn't quite straighten out the order of witnesses, I think, in terms of
well, that's where I was.
parties.
That's exactly where I was. And some people do this way in advance of the hearing. I prefer to do it immediately before the hearing for a lot of reasons. So we've got the EPA exhibits. I was asking who would like to go next. Let's see, there can be some tactical reasons to go last. I'm not going to do the lawyering for the lawyers. Very often I'll allow staff to proceed last. Are you fine with going last, Mr. Black?
Yes, Your Honor.
Okay, if there's no particular objection, I will have staff present their case last. All right, now let's talk about in between. I understand that the Attorney General does not have a witness or any testimony presented. Is that correct?
Yes, that's correct.
Okay, thank you. That's pretty easy. That leaves Mr. Simpson. Do you have any opinion about when you would like to testify, Mr. Simpson?
Sir, I guess I would prefer to go later rather than sooner, but after City of Las Cruces is fine.
Okay, so that's what we're going to do. We're going to put on EPA, a Coalition for Clean Affordable Energy.
Thank you. My only request is that my witness won't be available between 1:30 and 3 due to a separate work commitment.
Right.
That's today. So, I would recommend that Justin Brandt go later than some of the other witnesses.
All right, so let's do this. Let's do EPA first. They've got 3 witnesses. Let's then go with the City of Las Cruces. They've got 3 witnesses.
One.
Oh, I'm sorry. One it's one witness.
One with 2 pieces of testimony.
2 pieces of testimony. I don't know if I've ever referred to testimony as a piece, but yeah, okay. And then Mr. Simpson, and then Mr. Brandt, and then Mr. Dunn. Does that sound like a plan for us all? I think it could work. So if I get out of order, please remind me. So anyhow, we've got really one other issue I want to discuss with counsel. It's not really with witnesses, but with counsel. Well, there's actually a couple things. The one is, I believe because of the new regulation, which was amended on October 26, 2001, one of the issues or potential issues in the case is no longer an issue. And that's what I call the 3 and 5 under 7.7.28C1, sound like a lawyer here. Estimated plan year funding for electrical public utilities, energy efficiency, and load management program costs shall be expressed in dollars and shall be no less than 3% and no more than 5% of billing revenues from all customers' bills that the public utility estimates to be billed during the plan year to customer classes with the opportunity to participate, comma, excluding, then there's a colon. That is one of the worst run-on sentences I've ever seen. But the point is 3 and 5 rather than just 3. And there was an issue raised in the case. Does everyone agree that that's been resolved and it's no longer an issue? basically the amendment resolved it.
Mr. Hearing Examiner, I think that it was only raised as an issue in terms of a sort of a retroactive variance.
Was that
I don't think anybody has contested the fact that going forward, the company, has that 3 to 5% range.
Right. Well, that's what I mean. They could only, it was 3 to 4, and they wanted to use the 3 to 5 instead of 3 because of the new change.
And the city has made some points about the fact that the company should have made a timely request for variance under the old rule, but we have not specifically asked for relief or denial. So I guess I would just say that I think it's a legal issue that it doesn't need to be resolved today. Does that make sense?
I agree. And I saw a reference to, okay, that brings me to the next thing. There are legal issues in the case. As you all know, a legal issue is typically argued by lawyers in briefs rather than by witnesses through direct testimony or even cross-examination. I believe it was in the testimony of Ms. LaRocque. I might be wrong, but she referred to legal issues which she presumed were going to be argued in briefs. That struck me as kind of unusual. That's why I remembered it. And the reason I'm mentioning it is because briefs normally come after the case and after we have a transcript, so you can refer to lines in the transcript if necessary, which would include the cross-examination. Which brings me, pardon me, and bear with me just a moment. I'm pretty familiar with what I call statutes of limitation. And that reminds me of Reg 17.7.2.13. And the words that bother me are, quote, deemed approved as a matter of law. And that refers to the suspension of the rate, the new proposed rate, which was, of course, in the application. And to read the reg in full, it talks about the suspension, which was granted by the not granted, it was ordered by the commission, which is that suspension is limited to 180 days. So anyhow, I got my little calendar out and I started looking where does that 180-day lie. I find it lying right at about January 25th. I could be off a day or so. But frankly, for us to do this hearing and for us to, if we need a transcript, to do post-hearing briefs, and then I need to write a RD, and then it needs to go to the commission to schedule it for their next, hopefully even their next, it simply is not going to be done by the end of January. Now, where did these dates come from for this hearing, which is today and tomorrow? Frankly, they came from an agreement, came from my procedural order, which was based on an email from Mr. Kessler, explaining to me the agreement that was reached by the parties, wherein the parties agreed that the hearing would be on the 11th and 12th. Now, the reason I'm expressing it like that is because the party who would benefit by this automatic deemed approved, but as a matter of law, of course, would be EPE. And in order for EPE to agree to the dates of the hearing today and tomorrow, implicitly, I would think that they would not expect to rely upon those words deemed approved as a matter of law. Okay, that was a very lawyerly end around. And I'm wondering if Ms. Olson followed it and whether she has any comments about my comments.
Hearing Examiner Lennon, the company is obviously anxious to get this case resolved and get the plan approved. I understand the bind that you're in and the timing with respect to the rule, and the company wouldn't act unreasonably and is willing to consider reasonable solutions. Well,
I don't know if that was a bus or not, but it's a lawyerly vague answer. And I appreciate it and I respect it, and I would expect nothing less, actually. And I'm not asking for you to exactly commit, but it left that door open for you if you had chosen to do so. Also want to mention the history of this case. It began not with an application, but for a motion to delay the regulatory limits by 6 weeks, if my memory is correct. And so that's how the case begun, and that's how the case might actually, well, not exactly end, but might end. I think it's, I've read this statute several times, and I don't think there's any, I've read this regulation several times, and I don't believe there's any case law interpreting it, but it refers to an order by the commission suspending. It doesn't say there can't be another order of the commission suspending. So I believe the commission could either extend the suspension period or could issue yet another suspension period. It just says that the current suspension period can't be for a period of 180 days. It does not actually refer to whether there could be an extension of the suspension or that there could be yet another suspension period. So I've been, depending on how this case proceeds, I may ask the commission to extend the suspension or issue a second suspension to clean that up and make sure there is, frankly, no issue, just to dispose of the issue. So I've asked Ms. Olson, do you have any position, or would you object? I'm going to ask you straight. Would you file an objection if I would ask the commission to extend the suspension period or alternatively issue a second suspension period just to resolve any possibility that there would be a problem?
Hearing examiner Lennon, you've kind of put me on the spot because I haven't had an opportunity to consult with my client on this issue. I would imagine that the company would not likely object to a reasonable extension. I'm not sure that another 180 days
No.
be necessary. Do you have like the ballpark?
Thank you. I'm sorry if I wasn't clear. I certainly wasn't asking for yet another 180 days. But the way I look at it is slightly different. I want to do this correctly. I want to decide the case on the merits. If you prevail or do not prevail, it could be twisted one way or another that you prevailed or did not prevail because of the statutory limit rather than being decided on the merits, which is a much stronger case for you to prevail or not prevail. And, these cases are better resolved at the lowest level, like administratively, rather than in the courts on appeal, because of either being deemed approved as a matter of law, which could be, appealed, or secondly, prevailing because of the pressure of being deemed approved as an alternative, which would be, of trying to avoid that. I know this is getting complicated and some of this seems twisted, and I'm sure to the public watching on YouTube, they're not sure what we're talking about. But I understood your response. I understand you act reasonable. What I understand is that the commission reasonably extends, you would not file an objection. Did I hear that correctly?
Yeah, I think that's right. And to be frank, I don't think that the company reasonably expects that this case is, given that we're going to hearing today, would be resolved in 2 weeks. So
thank you. That's right on point. Exactly. And that's why I'm bringing this up before the hearing, because if you did, there may be a different fork in the road that we should take, basically, instead of doing the hearing. So that's what I needed to hear from you. Now, you're like I said, you're the party that would be the one to object, but I'll ask everyone else. Since you guys had agreed on this hearing date today and tomorrow, do the other parties, would they have any, I presume, do I presume correctly that you would have no objection to the commission well, I'll put it this way, not deeming the application approved as a matter of law pursuant to 17.7.2.13. Ms. Stevens, any opinion on that?
You're on mute, Ms. Stevens.
Yeah, you're muted. Can't hear you.
You're muted, Ms. Stevens.
All right, well, while you're becoming unmuted, Ms. Stevens, we'll move on to someone else so you can work that
I'm
out.
sorry, here I am.
Oh, there you are.
The city has no objection. I was just going to say that being in the last two cases, the 2016 case and 2018 case, I see that the 2016 case had a final order at the end of February, and the 2018 case had a final order in March. And both of those would have been, I think, filed without the 6-week extension. And
Right.
I cannot recall for the life of me whether there was a formal extension granted or not. So before you do anything, we might all want to check on whether that was even a necessity.
Okay. Well,
But we don't object, of course.
you
We want it
don't.
done right.
Right. I just wanted to do like a little roll call. You know, you guys already been with me enough to know how I do that. Miss Lynch, would you have any position on this issue?
I would likewise need to consult with my clients. And, I need to better understand the ramifications of the commission not granting the plan.
Well, the question is whether it's, when I see the words as a matter of law, it's basically at the expiration of the 180 days, which is the maximum for the suspension, that it's deemed approved, regardless of what happens at this hearing. And, that's not a resolution on the merits. But I actually believe that the commission can further extend or actually, I believe the commission can not deem it approved. That's slightly different. I think they have to do something for it to be approved. There's a few different ways of reading it. I could argue it both ways if I were counsel for one or both of the sides. I'm not at all. But that's the way I see that. All right.
So is this an issue that will be called to brief? And
not really, but I think it's I think it's something that you could mention. I would hope that I could get the commission to do either an extension or a new suspension even before the briefing period expires, just for some. It's more of a administrative housekeeping thing here within the commission. But I'm raising it now because, it's something that I recognize, that limitation period has not expired. But I see it as a 100-day limit on their suspension period. I do not see that at the end of the 180 days that the deemed approved as a matter of law shall occur. Makes any sense.
so I support any action that the commission may take to extend.
Yeah, thank you. This type of proceeding is, seems to be designed to resolve these matters on the merits, not with a statutory trigger, if you will, click that suddenly the egg has hatched. And
Agreed.
all right, Mr. Black, you actually work for the commission and at the commission. Do you have an opinion?
Staff doesn't object.
Okay, that might be helpful when I speak. Frankly, I don't go to the commission. I would go to the OG's office, the Office of General Counsel, because they represent the commission, and I would ask them to do some type of order so that that limit is no longer looming. Mr. Simpson, you're a pro se litigant, but certainly we would like to hear from you, sir.
Sir, I do not have any objection to whatever extension you deem appropriate.
Okay, well, it's up to the commission, I believe, to deem it appropriate, but I would recommend that they would, I would not enforce, that particular regulation. And however it's resolved, either by extension of a suspension or a new suspension, or however they resolve it. So anyhow, I think we have, if not, I think we have no objection before me.
You need Mr. Elliott's opinion.
Oh, Mr. Elliott. You know what, Mr. Elliott? Thank you, Mr. Lee. Mr. Elliott, this is precisely the reason I wanted you to be present. Because even though you're not going to present testimony and you're not going to examine, well, you're not going to present testimony, there are some issues. And this is one of those issues. So does the AG's office have any position about what I've been discussing?
We don't object.
Okay, wonderful. That's clear. So I believe I have no objection. It was all righty. I will put that on the record. One of the preliminary matters put on the record after Mr. Lee, after we turn it on with Mr. Lee. I think we have three things which we could resolve administratively right at the beginning of the hearing. One thing is the release of Mr. Gideon, because he is asked to not be present today. He's not going to present any witnesses, and he does not care to cross-examine witnesses, and it's his choice to not be present. So we'll raise that. I do that because, Mr. Gideon, there actually might be some sort of objection. Someone might have relied upon you being present, and I don't know that. It's not what I do. It's not my place to know those things, how each lawyer intends to present his case. So we'll give them an opportunity to express an opinion if they have an objection to you being released from appearing. Next, we have a order to compel, which was filed I received it at 4:59 p.m. from Ms. Stevens this past Friday afternoon. And that's all I have to say about that at this point, but I think we can address that as a preliminary matter. And then I also have a motion from EPA opposing CLC's motion to intervene. Now, they've been proceeding as an intervener. It wasn't actually in opposition to them appearing, intervening generally. It was as to them intervening in one of two capacities. So whether it's granted or not, CLC would remain in the case, and they have remained in the case. But I can dispose of that motion, I think, at the beginning of the hearing as a preliminary matter. Ms. Olson, do you have any opinion about whether we should dispose of that motion? Because, I could also just not address the motion or address it in the recommended decision. That's not a bus either, but.
Hearing examiner Lynn, to be totally honest, it's not something that I've given a lot of thought to, because the city is obviously in their capacity as the city has been involved in this proceeding and participated in. And so I guess either approach.
Your client agrees that they can represent the city as a customer, correct?
Sure, yeah.
They're here and they're going to remain here. They're going to be here. I'm not asking you to withdraw your motion, but, so it still is remaining outstanding. I could, I'm doing what I call housekeeping, cleaning up the case. I don't want any motions to be outstanding and unruled upon at the conclusion of this hearing. Because then I move to the next step, which is, well, we move to the next step. Ms. Stevens, do you have any opinion about ruling upon the EPA motion?
Mr. Lennon, the commission has mostly avoided ruling on this question in a number of cases. And I guess at this point, obviously we're here, that so long as you dispose of it in a way that does not violate the law as we see it, including the unpublished Supreme Court case and the published Supreme Court case that are cited, we do not need a positive ruling. We just don't need a negative one. I guess on that point is we just don't want it. We don't need a positive rulings at this late stage. We do not want the commission to, at this point in the proceeding, rule negatively unless we really want another issue, another legal issue in the case.
Well, I'll tell you guys, my fellow members of the bar, my objective here as the hearing examiner to give everybody a fair hearing, to follow the regulations, due process, of course, basically. And as a hearing examiner, I want to avoid reversible error, frankly. So my safest way is to not roll upon the motion. And it sounds to me like it sounds like that would be the safest way to proceed. And that's what I've done so far. And I can continue to do that. And unless EPA has a strong objection, and I didn't hear one, that's what I'm going to continue to remain not rolling upon the motion. I think that was clear. This stuff gets very confusing, and I apologize for being confusing. Ms. Olson, was that clear? Okay, I'm not going to roll on the motion. And they're still a party, and they would still be a party anyhow. That's one way of looking at it. Okay, that being said, are we ready to go on the record? And thank you, and I apologize, Mr. Lee, for this very extended off the record pre-hearing conference, which I like to do before a hearing just to make sure the hearing goes smoothly. Is there anything else? Yes,
Yes, Your Honor.
One quick question, Mr.
Okay.
Lennon.
Yes, sir.
As far as the city's motion to compel, are we going to get to argue that on the record, or have you disposed of it already?
Well, I haven't disposed of it, and I was going to do it on the record. If you'd like to discuss it right now off the record.
No. I just wanted to make sure that I didn't that it wasn't going away.
Well, I don't mind. No, it's not going to go away, but I don't mind telling you, frankly, none of the other parties have even had an opportunity to respond to this. So it's just too late. And, I'm going to give you an opportunity to explain why it was filed at 4:59 on Friday, right before, basically one business day before the hearing, if you'd like to do that. That's what I think you have a right to do. And if you have a really good reason why it was filed at that point without allowing the other parties the opportunity to respond, and why I should grant it, even though they haven't had an opportunity to respond, then we'll move to the next step, which is rolling upon it. But I don't think we're going to get to that point. I'm sorry to tell you how it's going to go, but that's probably how it's going to go.
I understand.
Okay.
I understand, but I would like to, for myself, make the record.
Well, I give you the opportunity. That's what I mean. I'm going to, there could be, I don't presume anything. There could be a really good reason it was filed at this time. Maybe someone, I'm not going to speculate. Maybe somebody promised you something and it didn't come in at 4:58 on Friday afternoon. I'm just making that up, but I don't think it's my place to speculate like that, and I'm not going to. All right, so now you guys, is there any other preliminary matters we should, any other things we could discuss during this pre-hearing conference? All right, thank you very much. So it's 10:45. Mr. Lee, it's almost up to your hour time for a break. Do we need a 5-minute bathroom break or anything like that from any other parties? Anybody? We do. Mr. Black would like to take 5 minutes? Okay, my phone says it's 10:43. Let's reconvene at 10:48. 5 minutes and we'll begin the hearing. Okay, everyone, my clock says 10:48, which was a 5-minute break. So if you could turn on your video, we will get started. Thank you. It's like Hollywood Squares or something, you know, I don't know what your screens look like, but I have boxes of all nice smiling people. Okay, make sure everyone's kind of here. EPA case manager, who is that? I'm sorry. EPA case management, EPE case management, sorry.
Mr. Hearing Examiner, that's Curtis Hutchinson. He's coordinating the transition of witnesses in and out of the witness room.
Okay. I think we went through this in another hearing, so I understand you guys do it that way. It's fine with me. It just threw me right there. I didn't know who it was.
Sure.
All right. So are all council ready to go on the record, officially start this hearing? Okay, thank you for a couple nods there. I didn't see any objection. Mr. Lee, are you ready to go?
Yes, sir.
All right, and thank you very much for being so patient with me in the pre-hearing conference. Mr. Lee does a great job and we really appreciate him. I'm ready to go on the record. On the record, Mr. Lee. Good morning. I am Robert Lennon. I'm a hearing examiner for the New Mexico Public Regulation Commission. This is an official hearing. We are officially on the record in the matter of El Paso Electric Company's application for approval of its 2022 through 2024 Energy Efficiency and Load Management Plan, Utility Incentive, and Revised Rate Number 17, Efficient Use of Energy Recovery Factor. This is case number 21-00114 UT. Welcome. There have been there has been a meeting, a pre-hearing conference before we began the official record. Mostly we discussed who was appearing for who, the order of the witnesses, and then I asked the parties to join me in discussing possible resolution of at least 3 relatively minor outstanding motions. So we're going to identify the parties and counsel for the parties, and counsel can also introduce the witnesses they expect to call, and then we will get to those 3 housekeeping motions, then we'll proceed to our first witness. So let's begin with EPE counsel.
I apologize, Hearing Examiner Lennon. Could you repeat what you were asking?
I am so sorry. I asked that you identify yourself for the record and who is your client and introduce your witnesses.
Yes, sir. Carrie Olson from Montgomery and Andrews, representing El Paso Electric Company, who will likely be referred to as EPE throughout the course of this hearing. And the we will be presenting 3 witnesses in this hearing: Ms. Araceli Perea, Ms. Amy Martin, and Mr. Adrian Hernandez.
Thank you very much, Ms. Olson. I have no particular order at this point, but let's go to Ms. Stevens. Who do you represent and who are your witnesses?
Good morning, everyone. I'm Anastasia Stevens. I represent the city of Las Cruces. And today, she just moved in the Hollywood Squares. With me is witness Lisa LaRock. She's the city of Las Cruces' sustainability officer, and she will be testifying about her own pre-file testimony and the testimony of city witness Jose Provencio, which she is adopting today because of his inavailability.
Okay. And we did also discuss that during our pre-hearing conference off the record. Ms. Lynch, who do you represent and who are you presenting?
Good morning. My name's Kara Lynch, and I am representing the Coalition for Clean and Affordable Energy, also referred to as CCAE. We are going to be presenting only one witness, Justin Brandt of the Southwest Energy Efficiency Project, and he will be testifying to his testimony that we submitted in this case.
Thank you, Ms. Lynch. Mr. Black, your client, please identify yourself.
Thank you, Your Honor. My name's David Black, and I'm counsel for the Utility Division staff of the New Mexico Public Regulation Commission, and appearing today as a witness in this case for Utility Division staff is Christopher Dunn.
Thank you, sir. Mr. Simpson, please.
Good morning, Your Honor. My name is Philip Simpson. I am a pro se intervener and resident of Las Cruces.
Thank you, sir. And you'll be presenting your written pre-filed testimony, correct?
That is correct, sir.
Thank you. And finally, not last but not least, Mr. Elliott, please identify yourself and your client.
Gideon Elliott on behalf of the Attorney General's office.
Okay. We'll move right. I had you last for a reason, Mr. Elliott. And the reason is because you've requested, although the Attorney General is actually a party in the case, you don't have a witness to present, is my understanding, and you don't have, and you waive cross-examination of witnesses, and you would like to be excused and to not appear at this anymore for the rest of the hearing. Do I understand it correctly?
Yes.
Okay, thank you. So does any other counsel representing any party have any objection to Mr. Elliott being released from being present during the hearing?
No objection.
Okay, thank you, Ms. Stevens. And I see Mr. Simpson waving his head no. Also, Mr. Black, no objection, right? No objection. Mr. Black, for the record, is indicating no. And Ms. Lynch is also, for the record, indicating no. So there being no objection, obviously the motion is granted. You're welcome to do whatever you like. You need not appear. Thank you, Mr. Elliott. You're released.
Thank you. Thank you all. Thank you.
Okay, the next thing I had, housekeeping preliminary matter was there was a motion filed by the city of Las Cruces for an order compelling El Paso Electric Company to respond to requests for production of documents. So this is a discovery motion, and discovery in these cases is largely completed and processed out of my involvement. Only when there is a discovery dispute do I need and do I get involved. And this document alleges a dispute and asks me to get involved. The important thing to me is that this document, frankly, I'll get right to the point, it was filed this past Friday afternoon at 4:59 p.m. of our local time, which is really too late to do anything on Friday. We don't really conduct business on Saturdays or Sundays, or we don't require people to conduct business on Saturdays and Sundays, although I'm sure many of us work on Saturdays and Sundays, and many of us might have worked on Friday evening. But still, it was filed on 4:59 on Friday, January 7th. And that would leave just yesterday, Monday the 10th, for counsel to confer with clients and to file any opposition they might have to this order to compel El Paso Electric Company. So the question is, do we proceed or will there be a hearing on this motion when El Paso Electric Company, the main party that would object to the motion, has had only one business day to prepare a response in a response to the motion. Frankly, I'm going to hear from the parties, especially Ms. Stevens and then Ms. Olson, about whether or not we should have a ruling on this motion, pardon me. And I will allow the other parties to opine if they have an opinion, but they need not. I suspect I'll hear from Ms. Stevens and Ms. Olson's only. So Ms. Stevens, it's your motion. It was filed late. I think it's filed late. Why should I consider this motion and why should I rule in your favor at this point?
Well, first of all, the Commission's general rule on motions is that motions should be filed at the earliest possible time, and that motions can be filed up to and including during hearing. The reason it was filed at 4:59 was to give some notice. Ms. Olson and I were still discussing. It was filed, it was written between probably 4:09 and 4:48 because we were still discussing it at the time, and we continued an email exchange even after the motion was filed, in hopes that there was a resolution. There isn't. But the gist of the and the reason it was filed that late was because the discovery response was filed on the 5th, which was Wednesday. On Wednesday afternoon, within minutes, less than an hour after receiving the response to a very, very simple question. The question was to provide the work papers in executable format for calculation of the UCTs, the utility cost test. The UCT is the very heart of a energy efficiency and load management plan. And the company in various ways did not object specifically to the fact that that they just didn't produce it. Essentially, they ran off a whole run of objections that did not apply to something as fundamental as the documents, the calculations that support the whole case. And if it were a minor matter, I would not be filing it so late, but it's not a minor matter. The energy efficiency rule says that the utility has the burden of proving that its program measures and its energy efficiency programs and measures are cost effective. And I'm sure Ms. Olson will object if I paraphrase her. I do have is one of the potential exhibits in this case, because in less than an hour I wasn't able to attach it to the motion. Some of our email exchanges, but basically the company's position, which is not reflected in their formal objections, which are reproduced in the motion itself, is that those calculations don't exist because they were done using a dynamic model. And I don't know whether I will be asking Ms. Martin and probably Ms. Perea as well what that exactly means. But the sum total of it is that the company is asking us to trust them on the calculations. And when we asked for the opportunity to have the calculations to verify, they stonewalled.
When did you request the information, the calculation?
The discovery was issued on December 21st, which was the Monday after our testimony was filed on Friday. And as we were working on our testimony, we realized that the only way we were going to figure out what was going on, and this is specifically about the residential and other lighting measures that are kind of the basis of our, was to do the calculations ourselves, or take EPE's calculations and pull them out ourselves. Because, if we had asked the company to run those calculations for us, they would have a very legitimate objection under the rules of civil procedure that parties are not required to do calculations for other parties that they have not done themselves. But presumably these are the calculations that they have done themselves. And now they're saying that they can't produce them.
Okay, thank you, Ms. Stevens. I've read the testimony. I've read your stuff. I understand you essentially want to carve out the lighting and the bulbs and that kind of stuff. So is that what you're asking for data?
Well, when we asked the interrogatory, that was our objective, to do that ourselves. But to be frank, the fact that the company has been so insistent upon withholding this information has raised more broad concerns about maybe we really need to look at all of the inputs, not just do that pulling out, because it's the core of their case and they won't give it to us. That's all I can say.
You requested on December 21st. When did they respond?
on the 5th of January, which is, I guess, the 15 days under the discovery rules.
Was there a reason you waited until December 21st to request? You stated that you had just received the testimony.
We had just worked on our testimony. We had received our previous discovery responses and knew from earlier in November, I guess it was, maybe it was December, I understood from that the company had not, the first set of discovery indicated the company itself did not do measure by measure UCT analyses. So after learning that, it kind of devolved into, well, if they haven't done that, we should be able to do that. But the right way to do that, of course, is to do it in the same manner as the company did, rather than to have Ms. LaRock go onto the internet, find a formula, do her best at cobbling together a facsimile of what they did, and then have the company tear it apart because it's not the model that they used. It's a sort of a lose-lose situation, but it seemed like that it was not. Think about a general rate case. The first thing that gets just shared is the electronic work papers. It's been discussed in past. It hasn't happened yet, but there was a rulemaking, I think it was 170045 UT, where the commission actually was discussing having all the electronic stuff as either a requirement for filing a rate case or even a pre-filing requirement. It's the same sort of thing.
Thank you, Ms. Stevens. Ms. Olson, I would like you to respond fully, please.
Well, hearing examiner Lennon, there's a lot of issues that Ms. Stevens appears to be conflating and misrepresenting. So I'd like to unpack this a little bit. First, I'd like it to be clear that Ms. Stevens raised this issue on January 5th, the same day that our rebuttal was due, the same day that our responses to her second set of interrogatories were due, and the same day that she had demanded that we supplement our responses to certain questions in the first set. And so she definitely had us under the gun trying to do this, but we, of course, have continued to try to work with her to get the city the information that it needs to present its case. As I think you noted early on, this case was filed back in July. The company's position was laid out fully in its case. The city waited to serve discovery until November or December, and then didn't raise this issue until the end of December, early January, and simply didn't give the company the time when Ms. Stevens demanded we produce the proprietary model on Friday for EPE to take the steps. So I'd like to, again, unpack that a little bit. The discovery response that is at issue in the city's motion is CLC 2-1, which asks for, in summary, work papers that used to generate final calculations. So I'm not clear, Ms. Stevens kind of went off on a tangent about measures and runs without the lighting programs, and that is not at issue in this motion. That is something that I'm assuming will be a subject on cross-examination. So turning to work papers for the final numbers, EPE, I believe, objected to the vagueness of the term work papers. EPE provided in its case in chief, ADM1, which provides all the inputs that EPE used to calculate UCT in response to the over 250 questions that the city of Las Cruces served in its first set of discovery. EPE further explained and provided additional information supporting the savings projections. And then in EPE's response to 2-1, EPE again tried to get across to the city that we don't have work papers as we understood the city to be requesting, but verified that they had given the city all information it needed for the city to be able to perform those calculations. In follow-up discussion on Thursday, in response to Ms. Stevens' demand to produce these work papers, I again explained to her that the company does not have the work papers as EPE understood 2-1 and 1-38 to be requesting that it could produce showing those calculations. And I again explained to Ms. Stevens that I understood the company had given the city everything that it would need to perform its own UCT calculations, but I told Ms. Stevens that I would look into the issue further and try to gain more information. After speaking with our witnesses and follow-up discussion with Ms. Stevens, I understood and the company understood what Ms. Stevens to be asking for is Frontier's proprietary model, or I apologize, as explained in the email that Ms. Stevens has referenced, that she has disclosed as a potential evidentiary exhibit, which I'm not entirely sure how communications between council could be evidence, but I explained that after further discussion with witnesses, the calculations come from and are part of a larger proprietary model, which contains a significant amount of other information and serves a broader function, similar to models that issue in other proceedings. The Frontier model includes complex formulas developed for a specific purpose at significant cost, and that production of such a model would put EPE and Frontier at competitive disadvantage. And I explained that EPE would need time to produce that model. And we simply, the day before the hearing, didn't have time to accommodate the city's request. There simply wasn't time in one day for EPE to produce that model. And moreover, there is additional concerns that the city may actually be a competitor, in which case the protective order protects against being required to provide proprietary information to a competitor. And we simply didn't have time to address or analyze these issues, particularly because this was effectively the day before hearing, and the company and its legal team were getting ready to present at hearing. And so I disagree with Ms. Stevens' characterization that the company is somehow withholding information. We have been very transparent. We've been very responsive to Ms. Stevens' extensive discovery over the Thanksgiving and Christmas holidays when EPE was putting together its rebuttal case. We tried our best to accommodate several requests to supplement discovery responses, and I continued to work with Ms. Stevens to provide the information that I could in the short time available to understand their case on this issue. But we were put in a bad position trying to address this on the eve of hearing. If it's something that the city had raised months or even several weeks ago, it's something the company certainly could have looked into.
Thank you. I think you covered it. I wanted to.
May I reply?
Well,
just a few little points.
Well, I have a comment. Let me see if I don't want to lose my train of thought here. Just a moment, Ms. Stevens. Since I had asked for clarification from you, I'm going to ask for clarification from Ms. Olson. You just went kind of fuzzy there, Ms. Olson. I'm not sure why. There you go. In the motion, Ms. Stevens any movement is required to obtain and then state the position of the other parties through counsel. Ms. Stevens indicates in paragraph 9 on page 4, due to time limitations, the city has not sought the position of the other parties and staff, who is actually a party. But before she states that, she says EPA opposes the motion and takes the position that the city has not engaged in good faith effort to resolve the discovery dispute. So my question, Ms. Olson, is it actually your position that the city has not engaged in a good faith effort to resolve the discovery dispute?
Mr. Hearing Examiner, I apologize. I'm not sure what's going on with our camera. But the truth of the matter is that we were in ongoing discussions to try to understand what it was the city was looking for and understand whether EPE could provide it. And it came down to there just wasn't enough time to address the issues. Ms. Stevens mentioned on the phone call that we had late Friday afternoon, I think she's already said this, we got off the phone shortly after 4, that she was contemplating filing a motion to compel. And I stated in passing that the company would obviously oppose a motion. I did not see the motion before Ms. Stevens filed it, and I did not give an express position on the motion. I think the initial email that Ms. Stevens sent to me demanding that a response or that the documents be produced within effectively 3 business hours, or she was going to file a motion to compel, does not demonstrate
Good faith effort.
reasonable or good faith effort. I will say that we continued to have discussions. I don't think that Ms. Stevens afforded sufficient time for the company to be able to address the issue. And so I don't think there was time afforded to make a good faith effort to resolve this issue. I think, as I mentioned previously, if it was something that had been raised earlier in this case, and I haven't heard any compelling reason why it couldn't have been raised earlier in this case, because again, it relates to EPE's direct case filed in July, I think we likely could have come to a resolution, but there just simply wasn't enough time allowed to get there.
Thank you. Ms. Stevens, I'm sorry to cut you off. Sure, you can comment, please.
I think I wanted to add that Ms. Olson is presenting this as something that all devolved on January 5th when they filed their response or didn't provide anything. But the question is plain as day and was out there on December 21st. So I agree. There weren't months, but there were weeks. And the question that I don't see how they could have that much difficulty understanding a question that just says, and it's in the motion, please provide an executable electronic format the calculations of the utility cost test or UCT for each proposed energy efficiency and load management program, including continuation of existing programs. Separate sentence, include all work papers used to generate the final calculations. Those are 2 separate requests. If the company was confused about the word work paper, if the company was confused about anything else, they had from December 21st to confer with the city and try to work this out. To say that it became my burden after they didn't answer, and they didn't, even their objections, which are in paragraph 4 of the motion, their objections have nothing to do with, they're quite generic. They have nothing to do with proprietary information or the modeling. That did come out as Ms. Olson and I were speaking on Thursday and Friday of last week, but that's not what their formal objections were. And when I sent an email Wednesday evening asking them to respond by noon on Thursday, this is all I had. The written objection that didn't say anything about proprietary anything, and didn't say that they don't. It didn't even say that they don't exist.
Right.
It just says, it just says it's quite generic. it does say seeks or would require EPE to either conduct studies or create information not readily available or in EPE's possession in the form requested. But that pops up in just about every objection that they have. And as I said earlier, I knew that that's the objection that I legitimately would have received had we asked for the company to provide runs without lighting measures. So we were aiming to do that on our own, a little self-help.
Thanks. It's almost like us lawyers get paid by the word. Sometimes is in fact the case, but if I could get the same information with less words, it might be appreciated. Our transcript cost from Mr. Lee would be a little bit shorter if we used less, if we were less verbose. Anyhow, I understand, Ms. Stevens. I don't want to cut you off, and I don't want to cut off Ms. Olson. You might have noticed that I did neither of those things. There is one thing I want to ask you, and I'm struggling to understand. Why are you essentially trying to help EPA to more completely present their case? Because it seems to me if their data is not supported in the detail you think is important, and you're helping them to present that data, it's adverse to the interest of your client. Am I misunderstanding something there?
I'm asking for the information. I'm not saying how I'm going to use it, I guess would be the short lawyerly answer to your question, Mr. Hearing Examiner. But as I said, we had an intended use for it, but when we were not given what we thought was rather basic information, it did start to raise other doubts in our minds.
Well, the doctors have a saying, first do no harm, and the lawyers have a saying, don't ask the question unless you already know the answer. I think you're probably familiar with both of those two things. And, I read your motion and I'm thinking, well, if this data is produced, it's going to strengthen EPA's figures, and they have the burden of proof. You don't. You can cross-examine them on the weakness of their figures, and this will do. This is going to strengthen their case if they fully explain their figures rather than these allegedly ambiguous figures. Without the supporting data. So really, I was struggling to figure that out, and I'm just asking you straight, why are you doing it? Your response seems to be, well, we didn't even get the information yet, so we don't know what we were going to do with it. Is that your response?
That is exactly the response. And they didn't put it in the record, in their case in chief. They didn't put it in the record in their rebuttal case.
So is it phishing?
They're not going to be able, if they chose to put it in, they wouldn't be able to put it in through, or maybe they would if I asked the wrong question of their witness and they get to do it on redirect. But that would really be, wouldn't that be a kick in the pants? But that was not where I was going. We did have I'm being honest with you. We had a direction that we were going, and the unexpected opposition has made us, think it through a little deeper, a little more deeply. Bad grammar, a little more deeply.
Thank you, Ms. Stevens. Let's see if anybody else has any position on whether this motion should be granted. Mr. Black, you're up in my left-hand corner, so for no other reason, I'll ask you.
Thank you, Mr. Hearing Examiner. Let me get closer to the mic. Can you hear me all right?
Absolutely. Yes.
Staff has no position on this discovery dispute. Staff does recognize that as Ms. Stevens said, for reasons of time constraints, that staff was not consulted before the motion to compel was filed. Staff is concerned that there is a tendency in matters like this to wait until the last moment to press the issue. And finally, staff is confused about the characterization by counsel for the city of Las Cruces that this particular discovery request is the core of the case, and staff is not aware that that discovery response or problem with the response has to do with data which forms the core of this case.
Thank you, Mr. Black. Mr. Simpson, like I said, no particular order. What is your position, if any?
Your Honor, I must confess I have not read the details of the motion to compel. However, I am inclined to support it based on my work and trying to understand the UCT values and wishing that there were details on how those UCT values were calculated.
Okay, well, I have a question for you. Why haven't you read it?
Honestly, Your Honor, I have been focusing on the technical aspects of the case, and I saw this come by in my email along with all the exhibits, and my inclination was that this was something for the attorneys, and it was a legal matter more than a technical matter, so I did not devote much time to it.
When did you see it?
I did see it Friday, but I did not pay attention to it over the weekend.
Thank you, sir. And Ms. Lynch, last but not least, I wasn't ignoring you. Do you have a position, or your client have a position?
I think I generally CCAE would support a party's motion. I just went back through my email, and on Friday at 4:59 is when we received this motion, and parties weren't allowed to, or weren't even asked for their position. So, from my stance as a lawyer, I do have some questions around what is a good faith effort in a matter like this.
Okay, thank you, Ms. Lynch. So there's no other argument for Ms. Olson or Ms. Stevens, correct?
Mr. Hearing Examiner, I would just say that to the extent this is a factual issue, Ms. Stevens does have opportunity for cross-examination of witnesses.
Thank you. And Ms. Stevens, because do you have any response to what Ms. Olson just said?
No, I agree.
Okay, thank you.
And I will. I just.
Well, I'm going to rule on the rule on it. I'm going to not allow or not grant the motion. So the motion is denied. Frankly, I'm glad we had allowed the argument to include the subject matter of the motion. However, I'm ruling for the record, in case anybody would think it's an appealable error, with prejudicial appealable error. I'm going to say for the record, it's too late. Frankly, it's just filed way too late to allow the other parties to prepare any response to the motion. 1 day before the hearing is not enough time to consult with the client and to prepare a response, be it written or even to prepare to present a response orally at the hearing. So the motion is denied. I think we've thoroughly presented the motion and the responses thereto. Motion is denied. Let's move on to testimony, okay? Let's go directly. Let's see, we don't need a break yet. So we're going to go with the first party and the first witness. Ms. Olson, are you ready to proceed with your first witness?
I am, Hearing Examiner. I will just check in with Ms. Perea, who's been sitting there patiently, to confirm that she's ready to go on.
I'm ready, thank you.
Okay, Mr. Hearing Examiner, EPE calls its first witness, Ms. Araceli Perea.
Thank you, ma'am. Please have her identify herself. Oh, yeah, excuse me. Let her be sworn in first by Mr. Lee, if you would, Mr. Lee, please.
Would you raise your right hand, please? You do solemnly swear the testimony you're about to give in the matter now pending should be the truth, the whole truth, and nothing but the truth.
I do.
Thank you.
Your witness.
Good morning, Ms. Perea, almost afternoon. Can you please state your full name for the record and spell it?
Yes, my name is Araceli G. Perea, and that's spelled Araceli G, middle initial G. Last name is spelled P as in Paul, EREA.
And Ms. Perea, can you please state your current position at EPE?
Yes, I'm the supervisor of El Paso Electric's Energy Efficiency Department.
And do you have before you what has previously been marked as EPE Exhibit Number 1?
I do electronically.
Okay, and do you recognize that document as the direct testimony that you pre-filed in this case?
I do.
And was that direct testimony drafted by you or under your supervision?
It was.
And do you have any corrections to your testimony?
I do.
And Mr. Hearing Examiner, it appears that the documents that we submitted last night include the corrections that Ms. Perea is about to make, but unfortunately they're not in red line. I'm not entirely sure what happened. So I suggest that Ms. Perea walks through the corrections, and then I will take direction from you or the court reporter if you want us to provide red line versions to replace the clean versions that we circulated yesterday.
I would like her to, on the record, present the changes. And you actually didn't send it last night. What we have from you is a link to your file serve system. You recognize that, right, Ms. Olson?
Yeah, Hearing Examiner, we've had issues that the attachments are too big for parties to serve, so we serve them on we provide them on the link to resolve size issues.
Okay, I understand, and it's really a technical matter. There is ways to reduce resolution and have the files smaller, and it's not directly on topic, but I do prefer them the other way rather than me having to sort through documents which you may not introduce to evidence and find the exhibits. So I have it in my hand, but it's a bit of a burden, frankly, for your legal assistant to just provide a link to a file service system which has a lot of exhibits, some which may not even be moved into evidence. So sorry for my statements that are on point, but to answer the question, yes, if this witness would please identify the changes. Frankly, like I said, I have a paper in my hand with my notes on it, and I'm literally going to cross out and make my own red lines, and the other parties can do that. If you would like to send the new version, reduce the size of it if you need to. Other parties are sending around exhibits of transcript without a problem. I've done it. There are ways to send it directly without using the file serve. As you know, I don't use lockbox as some hearing examiners do. By having to use your file service, it's essentially another type of lockbox, which I try to avoid. Anyhow, so with that being said, let's proceed with the testimony with the corrections. Thanks.
Mr. Hearing Examiner, may I? The version that I'm looking at does have the version from last night does have the red line and carry. It's in blue.
Okay, sorry about that then. I must be looking at the wrong thing. The last 24 hours have been a scramble. So disregard what I said. It looks like the corrections that Ms. Araceli or Ms. Perea are about to walk through are noted on the version, and Mr. Hearing Examiner, we're happy to provide the PDFs directly. We'll just send them in as many in multiple emails as other parties have done, as opposed to.
How many changes are there?
There's not very many.
Very few.
Well, I don't mind if we put it on the record, because I'm using the previous version, and I'd like to change it, and maybe someone else's as well. So let's-
Right, yeah, we'll walk through those. Okay, thank you. So Ms. Perea, if you could please walk us through the corrections to your testimony.
Yes, of course. The first correction is of my direct testimony is on page 2, line 21. And the word 10th should be deleted and replaced with 12. The second correction is on page 7 of my direct testimony, and that is on line 2. And it should add a reference to the rule, which is 17.7.2.19. D is in David and E is in Edward. The third correction is on page 10. Line.
Maybe.
Ms.
The
Stevens,
red line version does not, is there a mix of changes?
No,
Because
that was
that
the,
change is not on my testimony.
yes, that's correct. That was one that was not, that I inadvertently forgot to mention.
Oh,
Or
okay. So
it
this
didn't
is
get communicated properly.
thank you for bringing that to attention, Ms. Stevens. So there is some benefit to us going through that, and I'm
Yeah,
glad there's some
okay.
benefit, rather than just benefit to me. So we can all make these changes. Please continue with your witness, Ms. Olson.
Page 10 of my direct testimony, line 6. After the number 1,577,450, or well, 302, it should be KWH inserted.
I'm sorry, that number was 1,577,302.
No, I'm sorry, that's it shows it as 1,577,457,302. I apologize.
Next question.
Next correction is on line 20, page 25, line 5. And that should add Wi-Fi and thermostats.
Add it where?
Let's see. After star, it should read star Wi-Fi connected smart thermostats. Next correction is on page 26, line 16 through 17. And I'm just defining the acronym that was inserted. So the name of that acronym stands for Energy Conservation Measure. And then the next correction is on Exhibit AGP2. And on AGP2, on the 3 pages, there should be a footnote inserted that states administrative expenses includes EPE's internal administration costs of $211,956 recovered through base rates. And that was the last correction.
Could you speak a little slower? What additional footnote should be on all 3 pages?
Additional footnote should state administrative expenses includes EPE's internal administration costs
Thank you.
of $211,956. I'm sorry, $211,956 recovered through base rates. Are there any other questions?
Is that your last correction, Ms. Perea?
Yes, yes, that's my last correction of my direct testimony.
Thank you. And with those corrections, is the direct testimony that you prepared true and accurate to the best of your knowledge and belief?
It is.
And if you were asked these same questions today, would you give these answers under oath?
Yes, I would.
Mr. Hearing Examiner, EP Electric offers EPE Exhibit number 1, along with accompanying exhibits as corrected by Ms. Perea on the stand today.
Ms. Stevens, any objection?
I'm still trying to figure out that change because I'm confused because of the changes. Some of them are redlined, some of them, that last change, the administrative expenses one, is on the document I'm looking at, not redlined or anything.
Well,
Maybe Ms. Olson or Ms. Perea can explain that.
I understood it as an additional footnote, which is added to the charts on each of those 3 pages of that exhibit.
And I'm just saying that I'm looking at what was in the share file has that as the first note with the first asterisk. And I'd have to go back and see how they filed it originally to see what was changed.
Okay, well, your objection is noted, if that was an objection.
I'm just hoping maybe they could clarify.
Well, go ahead, Ms. Olson.
I apologize. I believe that Ms. Perea is making a correction today, which was made on the exhibit circulated yesterday.
Okay.
Add that footnote to what was originally pre-filed. Is that correct, Ms. Perea?
Yes, that's correct.
And
Does
it
that-
did not show up in red line. It just looks like it's just changed.
I think that's right. I'm not sure that we have the capability electronically to make footnotes red, which might be the source of that problem.
Okay.
Thank you. Once again, we all struggle with these kind of technical nuances, like not being able to put some red ink on a word or two. And if we all work with each other, we can make it through these technical challenges like Zoom and things like that. So I do appreciate everybody working with each other. We're all members of the bar and we have similar ways of thinking, doing things. So I do appreciate that. Let's go around and see if there are any. I'm going to consider that an objection, Ms. Stevens, but I'll give it.
No, don't consider that objection because I did pull up the original application as filed, and I see that first note, about the $211,000 was not there. There were 2 footnotes as filed, and that is just new text.
You withdraw.
I'm okay with that. I'm not objecting.
Thank you. Mr. Black, any objection?
No objection, Your Honor.
Mr. Simpson, any objection to admission of the EPA exhibit number 1, which is the testimony?
No objection.
Ms. Lynch, any objection?
No objection. Thank you.
Well, thank you. I have written on the front of my copy of the direct testimony of Ms. Perea on behalf of EPA's electric company, EPA El Paso Electric Company, dated July 15th, 2021. I have written EPA number 1 on it. It is now admitted as evidence in the case as part of the record. Let's proceed to cross-examination of Ms. Perea. Yes, ma'am.
Mr. Hearing Examiner, I apologize. I think we still need to move into evidence EP Exhibit 2, which is her rebuttal testimony.
Her what testimony?
Her rebuttal testimony.
Oh, I'm sorry. Sure.
Hopefully this will move a little quicker.
Okay, go ahead.
Ms. Perea, do you have before you what has previously been marked as EPE Exhibit number 2?
I do.
And do you recognize that document as your rebuttal testimony pre-filed in this case?
Yes, I do.
And was that rebuttal testimony drafted by you or under your supervision?
Yes, it was.
And do you have any corrections to your rebuttal testimony?
I do.
Can you please walk us through those corrections?
Yes. The first correction is on page 7. Oh, I'm sorry, page 21.
Okay.
Line 9. And I'm just, I'm sorry. So I'm adding the word EMMP. I'm sorry, not there yet. So I'm adding the word EMMP after the word values. The word values.
Sorry, MNB, did you say?
EMMP, E as in Edward, M as in Manny, and V as in Victor.
V is EMV, got it.
Yes, so that should read from lines 9 to 10 that it is the EMMB recommendations. Okay, the next correction is on page 22, line 4. And I'm just removing the word "the" before CLC. So it should read non-binding recommendations from CLC. The next correction is on page 23, line 2 and 3. So the first correction on line 2 should be inserted after the word life. So it should be the quality of life, period, the quotation marks, and then a reference of page 11, lines 12 through 14. With parentheses by the reference. Then on line 3, right below, should be examples of these are as follows, with quotation marks. And that was my last correction.
Thank you. And with these corrections, is the rebuttal testimony that you prepared true and accurate to the best of your knowledge and belief?
Yes, it is.
And if you were asked these same questions today under oath, would you give these same answers?
Yes, I would.
Mr. Hearing Examiner, El Paso Electric offers EPE Exhibit 2.
Any objection, Ms. Stevens?
No objection.
Ms. Lynch?
No objection.
Thank you. Mr. Simpson?
No objection, Your Honor.
Thank you, sir. Mr. Black?
No objection, Your Honor.
Okay, then the rebuttal testimony is labeled Exhibit Number 2. EPA Exhibit Number 2 is thereby admitted into evidence as part of the record and will be considered. Okay, so I don't think there's anything else from Ms. Perea. Can we proceed to cross-examination, Ms. Olson?
Yes, we tender our witness for cross-examination.
Thank you. I think it would make sense to go with Ms. Stevens first. Ms. Stevens, are you okay with that?
Yes, that's what I expected. Thank you.
Okay,
And
thank
I
you.
get to say good morning, no, just barely to Ms. Perea. How are you today?
Good morning. Thank you. Good. Thank you. How about yourself?
Okay, it's, yeah. So if you could turn to page 17 of your direct testimony, please. See, I'm not starting at the very beginning. Look on the bright side.
Okay.
On line 8, well, the question on line 6, the question is, does EPE's proposed portfolio of programs meet the utility cost test? And at lines 8 to 9, your answer is yes, EPE's proposed portfolio programs meet the
Sorry, could you slow down when you read that?
Oh, I'm sorry.
And at 8 to 9.
At
the
8 to
answer is-
9, the answer is, her answer is yes, EPE's proposed portfolio of programs meet the UCT. Please refer to the direct testimony of EPE witness Martin and exhibit ADM 1 for more details. So you did not provide the UCT calculations in your testimony, did you not? Did you?
I did not.
And but the city asked in discovery whether or not the company believed that only the portfolio needs to be cost effective. Is that right? If you could turn to CLC exhibit number 5.
Which one is that, Miss Stevens, CLC Exhibit 5?
It's exhibit number, CLC exhibit number 5, and it's also labeled EPE's response to CLC 1-4.
I don't know where that is. Is that in someone's testimony?
It would have been in let me see, give me a second here, I'll find the packet. I think it was probably in the first packet I sent by email yesterday afternoon.
Your Honor.
Excuse me, Mr. Black? I mean, Mr. Brown? Yeah, Mr. Black?
Thank you. I believe Ms. Stevens is referring to proposed Exhibit 5, which she and a number of parties took it on themselves to provide exhibits yesterday without the hearing examiner giving permission to do so or ordering it to do so. So what she's referring to, I think, is her proposed Exhibit 5, which was one of 4 emails that was sent late yesterday afternoon, proposing to send proposed exhibits for today's hearing.
Right, they're pre-labeled, but they are not exhibits at all and permitted, of course. So I understand you meant a pre-labeled document.
Yes.
Labeled as exhibit number 5. And I'm just trying to put my.
Are you having trouble finding it? Let me go back to my emails. I was trying to do them consecutively, except that sometimes I got bumped by the size limits in Gmail.
Right.
So, but it should have been the first grouping, I believe.
Okay, let's see that. This is some more of those technical challenges we deal with. If we were in a
I put all mine into a folder, so let's see. It is in the group sent at 4:17 p.m. or at least received. Look around 4:17 p.m.
I have one from you at 4:22 and 4:41. I don't have the 4:17.
No, you didn't get the first batch.
I have 4:22 and 4:41.
Does it start with mine was at 4:17? It's got the longer, it's the longer email message, which I know you responded to because it mentioned about Mr. Provencio's situation. So is it possible you saved it somewhere else because of that note?
Possible that when I respond to something, frankly, I move it to another folder.
Yeah.
Let me take a look if I moved it. I'm sorry for this. I really have my eyes on a document when there's cross-examination regarding the document.
It's the brave new world.
The brave new world. And this is exactly why, not exactly, but it's one reason I like to do hearings in person. But we all have to deal with this as best we can. I'm looking at my SENTS, my SENTS files, because I do recall responding to that one. I don't see it. Let's make this easier, frankly, for me. Ms. Stevens,
I can try to resend it.
Click on it.
I hope this will work.
Forward it to me.
I was at the right size limit at the time. So I hope that just by adding the
that does raise another question, whether it was carved out from my received email, but it couldn't be if I responded to it. Just please send it to me again.
Yeah, I'm doing that right now.
Yeah.
I think I'm doing that right now. My email can be
world that we live in. We don't have to wait.
Slow.
Well, as you did that, Ms. Stevens, your video froze, so your bandwidth is being exercised vigorously.
Oh no, I think better. And it may take a little bit because of being all the attached, but you're going to need them all, so it's the right thing to do.
Yeah, I'm pushing the send receive button because otherwise it only checks every 5 minutes or so. Well, I do not see it. Mr. Lee, could we go off the record for one moment?
Certainly.
Okay, while I'm waiting for that to come in, we're off the record right now, but we are on YouTube still. And while we were on the record, I got an email from Ashley Schenauer. Does anybody know that guy? Everybody knows that guy. He wanted me to mention to, I guess specifically the lawyers, that we are accepting applications for hearing examiner positions here. How about that? Miss Olson is smiling.
Mr. Lennon, I'm going to try sending it again because I found it sort of sitting in my outbox, and that's usually not a good sign.
Nope. Yeah, it's kind of weird like this electronic role we in. Mr. Black, did you hear my announcement? Are you going to send your application in?
Let's say it's under advisement.
Wow, that's very judicial of you. We could, all right. Anyhow, I actually did get that email from Ashley and he asked me to mention it. So while we're off the record and we have a tiny, tiny break while I try to get my hands on this document, I just thought I'd announce it.
I'm going to check.
Well, I thought I would basically
I don't
do what I was asked to do, Mr. Schenauer.
Judge,
And apparently,
I've got Miss Stevens' exhibits in a file on a computer in the other room. Would you like me to send those to you as well? I shouldn't have bandwidth issues.
Ms. Stevens, is that okay with you?
Whatever.
It's not coming.
I probably have messed things up by trying too many times. And
I've got them separated out and I can send them in smaller batches. Let me send that to you. Give me 3 minutes.
You know, the other thing I could do, I think, is if I strip off the note, it would definitely.
If Mr. Lee can do it, we're right now off the record. We're essentially taking a break.
I'm so sorry.
3 minutes. If anybody would like to use the men's or ladies' room during the next 5, please do so. Time is 11:56. We'll
does now say 12
noon.
You may end up getting this like 2 or 3 times. It does say sending.
Well, I got things from Mr. Dunn, actually. I got an email from Mr. Dunn, Ms. Stevens, and I don't know if he's trying to.
Well,
now, which exhibit are you referring to? How's it labeled? Number 5, right?
Yeah.
Okay, Mr. Dunn sent.
It's usually I can go to Gmail. Usually I can go to Gmail and see it goes out of Gmail faster than it shows up as sent in Outlook, but it's not showing up there yet either. That's not.
Mr. Dunn sent me something labeled number 5. It's El Paso Electric Company's response to City of Las Cruces' first set of interrogatories and requests for production of documents. Questions number CLC 1.1 through CLC 1-38. Is that what you were cross-examining with?
Yes, it says it's 1-4. It's an excerpt from the. Does it say interrogatory request for production CLC 1-4?
Yes, ma'am. Yes, it does.
Okay, we're good. I don't know what, I mean, you may get whopped with 3 or 4 email messages.
I'm gonna get yours. I got Mr. Dunn's, and now I'm gonna get the reporters.
Well, you may get many from me as well.
I've sent 10. I can send the rest. But I thought I heard that you had it resolved.
Well, I got it from Mr. Dunn. I didn't ask for it from Mr. Dunn, but I appreciate it. Let me push my send receive button and see what comes in.
What comes?
Yeah. Honestly, Mr. Lee, I didn't receive anything from you. It's probably in cyberspace between your office and here. That'd be right about St. Michael's Road, you know?
Indeed.
Do you have better service within the NM, the state.nm.us? I mean, are you actually functioning as
Who,
an
me?
internal system?
No, there's nothing internal with Mr. Lee.
Not with Mr. Lee, but with Mr. Dunn.
Well,
Maybe?
I don't know. I don't know it well enough, but I received it while you were trying to send it before. So if you want to refer to it, I should be able to pull it up from Mr. Dunn's email.
Okay,
There.
so it is labeled 21-11-0014-UC CLC Exhibit 5.
Are we back on the record?
No, sir.
1-4.
No, sir, we are not on the record yet.
Yeah, and I know we're not on the record. I just want to make sure that, I think that the rest of us were there before, on the record before we went off.
I allowed people to take a little bathroom break, I think, while you were still.
Some of them decided to take an hour of lunch.
I asked them to be back now, which is 12 o'clock, according to my watch. Miss Olson, are you there? And Miss LaRoque is there. Miss Lynch, are you back?
Ms. Prey is missing. Our witness.
Maria. Well, she's our witness, isn't she? So let's wait a minute or so. We'll wait a New Mexico minute, which usually is more than 60 seconds. Oh, she is right on time. Miss Lynch, are you there? We'll give her.
Okay. So, Ms. Prey, I'm asking you about this exhibit
We're not on the record, Miss Stevens. Stop.
because although you deferred the question specifically about
We're not on the record, Miss Stevens.
We
Please.
are on the record now?
We're not.
No.
Stop.
Oh, okay.
We are waiting for Miss Lynch.
Oh,
Sorry. We're waiting for Miss Lynch and Miss LaRoque. If you could turn on your video so I can see that you're there. Thank you. There's Miss Lynch. Okay, Miss Lynch, can you hear us? A nod? Okay. All right, Mr. Lee, could we please go back on the record? Thank you.
Yes,
Back on the record, I'm Robert Lennon. We took a break for some practical matters. I was trying to get my hands on an exhibit, which frankly I couldn't find in my computer, which was sent to me last night by Miss Stevens. I found it because Mr. Dunn graciously sent it in an email, and we tried to send it in some other ways. Then I suggested, since we're already off the record, that we just take a little bathroom break or coffee break, and now we're back on the record. So we were in the middle of cross-examination of Ms. Perea by Ms. Stevens, and she was going to ask Ms. Perea to refer to the exhibit, which I could not find. I apologize to everybody for these basically interferences, and apologize to the people that are watching on YouTube as well. So go ahead, Ms. Stevens, please proceed.
thank you. And thank you, Ms. Perea. I'm sorry about the delay. You have CLC Exhibit 5 in front of you, I trust, at this point.
I have CLC 1-4, is that correct?
Yeah, the answer is 1-4. The document that I sent you on yesterday is marked as CLC Exhibit 5, but you're right. It's the company's response to CLC 1-4. And if you look at the last page, it says that you were the preparer and you are one of the two sponsors. Is that right?
Yes, that's correct.
So would it be fair to say, looking at your answer to CLC 1-4, it's the company's position that only under the EU, the Efficient Use of Energy Act, only the total portfolio needs to pass the cost effectiveness test, which is called the utility cost test, or UCT. We'll get that acronym out there, because we're going to be using it the rest of the day. Is that the company's position, that the only requirement in law is to have the entire portfolio be cost effective?
Hearing Examiner Lennon, I'm going to object that Ms. Stevens is asking Ms. Perea a legal question. I'm also going to object to questioning on this exhibit without noting that these responses that Ms. Stevens is referring to are subject to objections, and I'm not seeing the objections included in this document that Ms. Stevens is questioning Ms. Perea on.
Thank you. Any other objections from any other parties? No. Okay, I'm going to sustain the objection, but maybe not for the reason you objected, with respect. Ms. Stevens, if you could break it, I call it breaking it down a little more, like tell me exactly where you're alleging that Ms. Perea is testifying to something in her answers to interrogatories. What number is it? What letter is it?
Okay.
Where can
I thought I mentioned A.
A.
As the answer.
No.
And it's on page 4 of 5 at the top. I mean, it does say, please see EPE's objections, and they objected and said, notwithstanding these objections, you know, we provide these answers subject to our objections.
Where's the answer?
The answer is on the top of page 4 of 5. The question is on page 1 of 5.
I see it. EPA understands that the overall portfolio programs is what needs to be cost effective based on the Efficient Use of Energy Act, prior orders of the commission, the rule 17.7.2.14, sorry, Mr. Lee, and prior orders of the commission approving electrical utility efficiency and load management plans. Nevertheless, EPA proposes cost-effective programs. So I understand what her answer was. What's the question regarding her answer?
The question is, because this is a discovery response, it's not part of her pre-filed testimony. I just want her to confirm that the company believes that the only requirement regarding UCT under the statute is that the entire portfolio be cost effective.
So when she says overall, that's really the catchword. So what does overall mean? Is it correct?
Yes, but I think the witness maybe should answer the question.
Well, I want to know what the question is first. And I understand your question, but
I'm not sure who's asking whom. At this point, I'm not sure who's asking whom what.
Ask the witness if she understands your question. Ms. Perea, do you understand the question?
I don't fully. I'm not sure what she's asking.
Let's try again then. So it's EP's position that the only thing that needs to be cost effective based on the UCT under the statute, the rule, and prior orders is the overall portfolio of programs. Is that right?
EP understands that the overall portfolio of programs is what needs to be cost effective based on the EUE Act and the Commission rule and prior orders of the Commission approving electric utility energy efficiency and load management plans.
And then in that same answer A, you go on to state that nevertheless, EPE proposes cost-effective programs. Does that mean that EPE believes that when it proposes a cost-effective program, it is doing so voluntarily and not because the statute or the commission orders or rules require it?
EP.
I apologize, Mr. Hearing Examiner. I'm going to just continue my objection that this is calling for legal conclusions, but I don't want to continue interrupting Ms. Stevens. So
To your objection noted, overruled. Witness, you can answer, please.
EP is proposing a cost-effective programs.
Next question.
And then, so the next question, this one we do need to refer back to page 2 of this exhibit. I'm going to direct you to question labeled I, as in ice. And the question is, has EP ever requested that the commission approve an energy efficiency or load management measure that the company projected would not be cost effective in the long term? And then it goes on to say, if it's, if the answer is yes, identify it. If your answer is no, why not? Now, if you flip down to the answer, it says your answer was no. Please see the response to CLC 1-4A. Now, and I'd like you to explain to me what is the meaning of a question that asks about measures, and then you refer to your previous answer that discusses the cost effectiveness of the overall portfolio and cost effective programs.
That goes back to my statement that EP understands that the overall portfolio of programs is what needs to be cost effective when we present our plan.
Do you understand that the question was just a simple factual question as to whether the company had ever proposed a measure that was not cost effective, and your answer does not discuss measures. It goes back up to the testimony about portfolio.
We don't run tests on cost effect on measures for our portfolio program.
And would that, if we look at the testimony, your discovery response here, does that correspond to answer T? Describing the process which concludes with a UCT for each measure is not calculated as part of this process?
Sorry, describing the process.
Answer T, which describes the process and concludes with the sentence that reads, quote, a UCT for each measure is not calculated as part of this process, end quote.
Mr. Hearing Examiner, it doesn't appear that there's a question.
Yeah, no, the question was, does Ms. Pereira's oral answer correspond to this assertion in T that the company does not calculate UCT measures?
Overruled, and I'm looking at T, and I'm not sure that's what T says, to be frank with you, Ms. Stevens. Ms. T refers to Amy Martin's exhibit number ADM1. Am I correct, Ms. Stevens?
Right.
Seems to be somewhat of a comprehensive response. I don't understand if you're implying that it was not a comprehensive response.
No, I'm not implying anything. I'm trying to elicit some clarification about, well, let me try something else. Basically, the end question here is, Ms. Pereira, when you answered that the company does not, in response to I, when you answered no to the question of whether the company has ever requested that the commission approve a measure that the company projected would not be cost effective, is the answer no because you never project the cost effectiveness of individual measures, or because
excuse me, so there was a little I disconnected a little bit, so I didn't hear your whole statement.
Oh, okay, I'll start over again then. So comparing your answer to I and your answer to T, is the reason that you said no to the question, has EP ever requested that the commission approve a measure that the company projected would not be cost effective? Is the no answer the result of the fact that the company does not project cost effectiveness, or is does the no reflect that the company has a policy of not proposing measures that are not cost effective?
So as I stated in question T, the costs and benefits of each measure within each program are combined to produce total program costs and benefits, which are used to calculate a single UCT result per program.
Thank you.
Does that mean that the company, when they propose a program, that you don't know whether an individual measure is cost effective or would be cost effective?
That's correct.
Now, when staff asked EPE whether the new FutureWise component of the Smart Students program would be cost effective, would you turn to CLC exhibit number 4? That's the staff interrogatory.
It's going to take me a minute, please.
Yeah.
Thanks.
That should be in that first bunch.
I'm looking. Okay, thank you for waiting. I've got it, please.
Now, in this interrogatory, which has been discussed in staff's testimony and the city's testimony, and I think in Mr. Simpson's testimony, you indicate that the company did do some sort of a cost effectiveness test on the separate kits in the proposed Smart Student program, correct?
I'm sorry, proposed
kits in the Smart Student program.
I don't see where this is this witness's testimony, Ms. Stevens. It looks like it was testimony of Amy Martin actually responded to
If you
interrogatory.
look at the bottom,
Yeah.
Ms. Perea is also a sponsor.
Sponsor, okay.
Yeah.
Well, this is a corporate party, so I'll go with that. It's not really a sworn testimony, so to speak, of this particular witness, and that it's a corporation responding. So it changes the cross-examination ever so slightly, at least the way I see it. So I'm sorry. Why don't we ask her if she actually prepared this particular answer and whether that language is her language? I would like to know that.
This is not my language.
Okay, well, you can answer my question too. Who prepared this language on these answers to interrogatories, Ms. Perea?
Amy Martin.
Okay, so is she going to testify today? Do you know, Ms. Perea?
Yes, she is.
Okay, so it might be a question to hold off Ms. Stevens for Ms. Martin. It would have more impact through Ms. Martin. That's just what I think. I'm not telling you again how to do your.
Yeah. And I'm going to ask because I think that this question is pretty simple when we get to it, So is this an instance, and also Ms. Perea, you've testified and included in discovery responses that the process of selecting the programs and the measures is an iterative process, and you and Ms. Martin work very closely. Is that right? Going back and forth? Is that a good takeaway from all the testimony and the rebuttal testimonies?
And your question is if we work together? What was your?
Do you work together and go back and forth on refining the program offerings? Is that right?
On the program offerings specific, no. EPE decides what programs we're going to offer.
Okay. And how do you use, this is a very broad question, so you tell me the story. How do you use Amy Martin and Frontier, I'm not sure it's only Ms. Martin, to help you decide what's going to be in the programs, what programs you're going to offer and what's going to be in them? Could you just kind of walk us through the process?
Well, we asked Frontier to evaluate certain programs for us and run the UCT calculations.
And when you say you have them evaluate certain programs, do you give them all the description of what the program is going to be like, what measures are in the program, who are the targeted customers, who you expect the the implementer or implementers to be, how much you expect the administrative cost to be, or do they just run the UCT numbers, or do they work with you on defining all those other parameters?
Ms. Stevens, that was at least 6 questions.
6 questions, okay.
Maybe, I was counting them as you were asking them.
Okay.
You could ask one question at a time.
When you work with Frontier, do you give them, do you dictate to them the name of the program?
Thank you.
We're going to do this one by one. Do you dictate the name of the program?
But we tell them, maybe not so much the name because we might not know that, but the program that we have in mind. Yes.
Okay. And do you tell them what the contract terms are with the anticipated implementer or implementers, the cost elements?
Yes, for the program, yes.
So when you give them the administrative costs, do you give them the full data so that they can apply them to the number of measures or things, or do you just give them a number?
That was an either or.
That was an alternative question.
Yeah, one or the other, but no other options. So what is?
Well, she can give me another option.
I'm sorry. So
okay. So when you give information about the administrative costs of an anticipated program to Frontier, do you just give them a dollar figure, or do you just give them a dollar figure and say, this is what we expect the administrative cost to be?
Yes, that's correct.
And do you give them a dollar figure for the marketing costs?
Yes, we do.
And do you give them a dollar figure for the M&V, measurement and verification costs?
Yes, we do.
So it sounds, and then what else do you give them do you give them a list of all the individual measures that you plan to put in the program?
Yes, we do. And I should state, Amy Martin goes into more detail in her testimony and explains this process.
Well, I'm trying to figure out, since you're the witness who, it sounds like the company is making a lot of these decisions. I want to ask the questions of the person who's the decision maker, and that sounds like it's you. Is that correct?
Yes, it is.
So you select the measures that you'd like to include, is that right?
Yes, that's correct.
And do you provide Frontier with your estimated or targeted number of participants or users of each of those measures?
They utilize that with the past participation rates. They'll look at that.
And that's information that comes from you or from ADM or from Frontier or somewhere else?
Comes from us.
And do you provide the estimated annual savings for each of those measures?
No, I do not.
Is that something that comes from the M&V evaluator or from Frontier or from some other source?
Well, it comes from the TRMs, the New Mexico, mainly from the New Mexico TRM and other TRMs that Amy Martin mentions in her exhibit ADM1.
And now, is that a number that if you're going to the TRM, are those TRM numbers that you are passing along to Amy Martin and Frontier, or are they the ones who are responsible for looking at those numbers?
We give them the TRM,
Okay.
and it's, I should state, it's the technical resource manual.
Thank you for doing that. I'm sure the court reporter is going to. So you give them the states, and that would be true of the energy projected energy savings from the TRM that you provide. Is that right?
No, that's not correct.
Well, explain then.
Frontier calculates the energy savings, the projected energy savings.
How well? So you give Frontier the name of the measure, the description of the measure. You're giving them the TRM savings assumptions. Would that be a better word?
The TRM has the savings per measure.
And you just said that you are giving them to Ms. Martin. Is that right?
I'm not sure what you're asking.
Do you select the TRM figures for a particular measure and just hand them over to Ms. Martin?
No, Frontier utilizes a TRM that contains all the measures that are available for El Paso Electric to utilize and to offer to their customers.
And from that TRM, does Frontier, not the company, decide what the energy savings and the demand savings are going to be? Is that right?
The TRM states the energy savings, the energy and demand savings per measure.
And the estimated useful life, that's another input into the UCT, is that right?
Yes, it is.
Does the company select that figure, or does Frontier out of the TRM or from some other source?
The TRM provides that, provides the estimated useful life.
And does the company provide the discount rate for the calculations?
Yes, we do.
What other information does the company provide that is, specific to your experience or with the programs that goes into the UCT calculation, if any?
As I mentioned, Amy, that information is in her appendix of her ADM1, the avoided costs.
Oh, and
measures.
So those avoided cost figures, they come from El Paso Electric?
Yes, that's correct.
And that's avoided energy and avoided demand costs?
Yes, that's correct.
Does EPE, as the administrator in the big sense of all these programs, do you provide kind of less quantitative data about your expectations as to participation levels, things like that?
I'm sorry, can you repeat your question?
So do you tell Frontier that we expect to have 14 people want high efficiency air conditioners? Is that a decision that comes from the company based on its on the ground experience, or is that a number that Frontier works out for you?
Pardon me, I'm going to have to interrupt, Ms. Stevens. I apologize for interrupting you, but what you just stated was not the last question you asked Ms. Perea. Your question was, does EPE provide less quantitative data? And then you were asked to repeat the question, and the question you repeated really was not the question you were asked to repeat. So
I thought I was trying to clarify or make the question more understandable, but maybe maybe I was
to me.
misleading. I hope I didn't confuse you, Ms. Prey. I was trying to help.
You know, I read the transcript back sometimes to clarify for me if I don't understand a question or an answer, or both a question and an answer. But I don't think that would have made sense even if I read it back. So I think the point you're trying to make, it, correct me if I'm wrong, is that all the data for the UCT comes from EPA, the movement for approval, correct?
Well, I'm trying to figure out which comes from which side, because to be honest, Mr. Lennon, in the last case in 18-00116 UT, Ms. Perea deferred a bunch of questions to Ms. Martin, who then said, oh, we don't make those decisions. So this is, and I know it's 3+ years later, but I'm kind of going over old ground. I think she's sitting there, Ms. Perea sitting there smiling. So I think she knows what I'm talking about. Is that I guess we were under the impression going into the previous case that Frontier did more decision making. So I'd like, now that I have Ms. Perea under oath, I'd like her, to explain on the record what the process is.
Well, thank you. Once again, I'm confused as to why you would want to help them make their case if their case has to this date been made weekly, WEAKLY. And by asking these questions and this whole line of questioning, you're strengthening their testimony rather than weakening their testimony. And you've kind of baffled me about that.
I think that remains to be seen. And I also think that we want to have a fair understing before we make, I think understanding is the important thing. This is not like, this is an administrative hearing. We are all here. We're going to be working on these programs together, as Ms. Perea knows, and she's testifying about working with Ms. LaRocque and Mr. Provencio and City of Las Cruces and Las Cruces Utilities. We want this to be we want these programs to succeed, and we just want to understand how to make them succeed the best.
Thank you.
It's not as hostile. I guess I'm trying to say it's not as hostile as all that. I feel like an idiot saying something that blunt, but that's pretty much what I have to say, is that, understanding leads to eking out the refinements that we're looking for here. We're not trying to blow up the company's program.
Okay, let me respond. And, I want to move the case along without prejudicing any party's interest or right to examine and cross-examine. But I will, and I want more information rather than less information as a general rule, and I weigh the evidence.
I'm sorry, hearing examiner, you cut out. I get these little glitches everywhere. So every once in a while that it just disappears a few words.
Okay. I don't know what was cut out, but I said that I like more information rather than less information as a general rule, but not redundant. And I mentioned that because I had frankly presumed that the data to calculate the UCT comes from EPE records and information and accounting and figures. I can't presume that I would not think that it came from anywhere other than EPE. So your entire line of questioning was about whether the data comes from EPE. And of course it does. So if you're going to present evidence that it comes from somewhere else, I'd like to know about that. But where else could it possibly come from? And I'm wondering why you're helping them to clarify that, of course, it comes from EPE. So
I don't want to argue with you, Mr. Lennon. I mean, Ms. Perez said that Frontier does the calculations and Frontier does the TRM work. It really is. And again, I do believe that the testimony sort of indicates that it is a iterative process where they do go back and forth. And I want to figure out where the back and forths are, because the concern that the city has is, I think it's pretty obvious, is that those lighting measures are suspect because of the imminent, potentially imminent major changes in the law, and that they're so deeply embedded in some of these programs that we're trying to figure out how to deal with that.
I know you want to separate those out and evaluate them. I read the testimony of your witnesses, so I actually kind of know where you're going. But if someone hadn't read it, they wouldn't, frankly, know where you're going with this testimony. So well, I'm going to let you proceed as you wish. Like I said, I'm not going to try anybody's case here. I'm going to let you try your own case. But I'd like to move it along perhaps a little quicker.
I'll try to move it along quicker. Sorry, both of you. So Ms. Pereira, let's go back to where this was a while ago when we first looked at CLC Exhibit 4, which is Staff 1-4, and the fact that that EPE did run initial cost effectiveness tests on new and existing measures. Is that a process that the company engages in if you're going to adjust a program?
Yes, we are engaged in that process.
Okay. So for example, when you added the refrigerator, freezer, and air conditioner recycling measures to the residential comprehensive program, did you do similar initial cost effectiveness tests with and without those measures?
I don't remember. I don't recall on that part.
Do you recall whether the fact that it was done for the elementary school and the high school portions of the Smart Students program, was that a typical process or an exceptional one in your estimation?
And your question is regarding the FutureWise kits, is that correct?
Yeah. Well, when you did the separate UCT, or had Frontier do separate UCTs for the program with and without the high school program, was that kind of your usual protocol when you're making changes to a program, or was that an exception?
The FutureWise kits has multiple measures in it, and as it's stated in in Staff 1-4C, page 2 of 2, that was initially seen as a program because it's multiple measures within that kit.
So are you suggesting that you were considering doing a separate elementary school program and a separate high school program?
Yes, that's correct.
Hearing Examiner Lennon, I apologize for interrupting, but Ms. Stevens is referring to it as the high school and elementary school program, and Ms. Perea is referring to it by the program name, and I think there's some confusion.
Okay.
Well, I heard her answer the question as if she understood what the reference was to, so I'll rule the objection. I understood her response.
Okay.
So, but Ms. Stevens, it's a good point if you could be more correct, if you would, in the terminology. We all have this crazy terminology, and it's really proprietary terminology. I mean, when I see words in this testimony which uses symbols which aren't even part of the English alphabet, it strikes me as unusual. So there's all these proprietary terms and things. As long as we all use them and as long as we understand what they mean, it's fine. But if we could be just a little bit more precise, Ms. Olson would probably be happier, at least. Thank you.
And to make the hearing examiner happier and Ms. Olson happier, and probably not you happier, Ms. Bray, because I think we understand one another. But so what we're talking about is that to just recap your testimony is that the company first considered the FutureWise packet of student kit program as a program, and the pre-existing LivingWise elementary school kit as a separate program, and that's why you did the separate UCT calculations discussed in CLC 4. Is that right?
I'm sorry, Ms. Stevens, I lost you there.
Oh,
what was your question that?
So to recapitulate your testimony with the right names, is that because the company saw the kit that constitutes the FutureWise program, which I referred to previously as the high school students, as a separate program because it comprised multiple measures, and saw the LivingWise elementary school kit program as a separate program because it comprises multiple measures. That's why you ran them. That's why you did these preliminary or initial cost effectiveness tests as separate entities, separate programs. Is that right?
As I stated earlier, the FutureWise kit has multiple measures, and we had ran a cost effectiveness as looking at that as a standalone program. I think that answers your question.
I think that does, and you did say it before. I just wanted to put it in the right words. Thank you. So if you turn to page 15, I thought the city would move to admit CLC 5 and CLC 4.
Which are actually discovery documents, interrogatories and response to interrogatories. Let's see if there's any objection, Ms. Stevens. Ms. Olson, any objection?
Hearing examiner Lennon, as I noted earlier, these responses are just the responses. They don't include the objections under which these responses were made. And so my objection to introducing these in the record is that they're not the complete response because they don't include the objections that were made in connection with the responses.
Why aren't, Ms. Olson, why aren't the objections in the responses?
So they are as part of the responses. The objections are legal objections, so they're not sponsored by the witnesses. And so Ms. Stevens has isolated the witness responses without including the legal objections.
Well, cross-examination is cross-examination. And I consider it an effort and a correct effort to either impeach the veracity of the witness or to impeach the reliability of evidence, or to, in this case, perhaps to introduce evidence. I understand the reason these responses are offered for admission into evidence, as to breaking down whether or not the UCT was above 1 or below when measures or smaller portions are considered. And I understand that's a point Ms. Stevens is trying to make with this. I think it's relevant, not very relevant, but I certainly think it's relevant to issues in the case. So I'm actually inclined to admit these two documents, and I'll give them the weight which is appropriate. Thank you for your objection, Ms. Olson. Let's see if anyone else has any objection. Ms. Lynch, an objection to omission of these two discovery devices?
No.
Thank you, Mr. Simpson.
No, Your Honor.
Mr. Black?
No objection.
Okay, let me make sure I know exactly what you're talking about, Ms. Stevens, because I'm going to mark them, admit it. So you want to, okay, you tell me what you want to admit again.
Okay, I'd like to admit the document that's been marked CLC Exhibit 5, which also says EPE's response to CLC 1-4. And I'd also like to admit CLC Exhibit 4, which is labeled in the PDF document, EPE's response to staff 1-4.
Okay, yeah, that's what I understood. I just couldn't state it correctly.
And as I was preparing my cross-examination, I was pleased and shocked that most of my questions ended up being fairly chronological in terms of the exhibits that I had numbered. I didn't think I was that organized in my head. So I hope that we'll be keeping going roughly in numerical order.
So those documents, CLC Exhibit number 4, CLC Exhibit number 5, as labeled, are admitted as evidence in the case.
Thank you. Ms. Pereira, let's turn to pages 15 and 16 of your direct testimony, which right now is eluding me. And here you talk about the addition of 15. Let's see. Now, where is it? Actually, talk about the addition of the, sorry, I have a bad citation here. Oh, here in the bottom of 16, talk about adding the appliance recycling measures to residential comprehensive program. And you testify that that's a popular, it's been successful in Texas, is that right?
Yes, that's correct.
Is that a standalone program in Texas?
It is.
And in case number 18-001-116-UT, the commission disapproved a proposal for a standalone appliance recycling program in New Mexico, didn't it?
I'm sorry, and is that, can you direct me to where that is in my direct testimony?
Oh, no, I'm just asking you, because you were in that case. In that case, the commission did disapprove the recycling program, didn't it?
The appliance recycling program?
The appliance recycling program in the last case 3 years ago?
Yes, it did.
And do you recall that the reason that the commission gave was because it was marginally cost effective under the company's calculations, and then the commission had doubts about the company's or some of the company's assumptions?
Anastasia, you're breaking up.
Oh, I'm sorry. I wonder what.
I think it's my speaker, but
yeah, I don't know, because I just raised my volume for you because I'm having difficulty hearing you, but it's not breaking up. It's just soft.
Okay.
Let's do wave, scream, whatever, whenever things go bad, because I raised my volume and it helped.
And I'd ask not testify, Ms. Stevens, because frankly, it sounded like you were actually testifying rather than asking a question for a moment there.
Okay, so back in the other case, do you recall the reasons that were given for denial of the disapproval of the proposed new standalone recycling program, appliance recycling program?
Yes, I do.
And what were those reasons?
The reason was because we used the free ridership of 0 and a UCT value, EUL of 8. And those were the two reasons. And it was because it had a low UCT, even though it was still cost effective. The commission saw it as like low, but it was still past cost effective.
And in this case, EP is proposing to use the same contractor as it did in 2018, is that right?
And this is for the appliance recycling?
For the
program?
appliance recycling program, yeah.
Yes, that's correct.
And do you have a different contract with different terms?
We do not have a contract.
How do
I'm sorry.
have
Ms. Stevens,
do you have a projected contract?
Can you please clarify?
We are breaking up. I don't know what to do about that.
No, we're not breaking up, but I'm asking if you could please clarify your question. Because you're asking about Texas and we're in New Mexico, so I'm not sure.
Yeah, we're talking about the New Mexico proposal now.
Okay.
Okay, does that help?
Yes.
Okay, so for this proposed New Mexico measures that you're now proposing them as measures within residential comprehensive, right?
That's the appliance, yes, the appliance recycling part of it.
Okay, but to do within the proposed revisions to the residential comprehensive program, will you be using the same contractor for the appliance recycling measures as you did in the previous case 18116?
Yes, that's correct.
And did you go out to bid or do anything to get different terms than what you proposed in that case?
No, we did not.
And that contractor is not one of the one of the contractors presently for the rest of the residential comprehensive program, is that right?
I'm sorry, can you ask me that? Can you clarify your question?
The contractor for the recycling is the contractor for recycling currently a contractor as part of the New Mexico residential comprehensive program?
Currently in our existing, we do not have recycling in our 2020, 2021 program, in our existing programs.
And this particular contractor does not provide any other services within residential comprehensive as it currently exists, does it? Does this contract?
It does not.
So the costs for this these new appliance recycling measures would be quite distinct from the rest of residential comprehensive. Is that fair to say?
I'm not sure what you're asking. We could be more specific.
Yeah. Are the costs of the resident, if it's approved, would the appliance recycling program just add a complete new set of costs because you're using a separate contractor?
Yeah, I'm sorry. Let me try something different. Okay, there. Can you hear me?
Yeah.
Okay, let's try this.
Yeah, you're louder, a little louder now. I don't know what you've done.
Okay, all right. I apologize.
Thank you. So the question was, because the contractor is different and not part of that program, are the costs of the appliance recycling measures going to be fairly quite distinctly separable from the rest of the program?
You're saying the incentives for the recycling units that we pick up?
Not the incentives, but the overall costs, including incentives.
And you're saying if they're going to be distinct from our residential?
Well, can you easily distinguish them because they're going to be worked through a separate contractor?
Yes.
Has the contractor reduced its costs since the previous case? And I'm not asking you to give me numbers, just.
I don't know. I couldn't answer that question.
has EPE done anything, or the contractor done anything to make the recycling program more cost effective? The recycling measures more cost effective than they were 3 years ago when they were rejected by the commission.
I guess your question, the commission did not reject the measures. I mean, they rejected the program, so I'm not sure what your question is.
So it has EPE done any, has EPE or its contractor done anything to improve the cost effectiveness of appliance recycling since the last case?
Well, that goes back to, I guess I'd have to refer that to Amy, but the way we calculate, as I stated earlier, the free ridership, we're not using zero, and we made those corrections that the commission ordered us to. And the one thing we are including is the window AC units, which we hope will help the cost effectiveness. If that, I think that answers your question.
I think I lost you a second there audibly. Did you say that the air conditioning measures improve the cost effectiveness?
I'm not sure. You'd have to ask. I guess Amy would have. I'd have to defer that question to Amy.
Yeah. So we're back, I think, to where we were with the first discovery response, where you're saying that the company just determines cost effectiveness on a program level and not on a measure level. Would that be an accurate statement of what you're just said about we don't look at them as measures? We don't look at them as a program?
So as well, that is a appliance recycling program that you're asking me questions on, and Amy would have to answer the questions on the UCT part of it.
Yeah, Ms. Pred, you were here this morning for the discussion about the company's failure to produce discovery responses.
Objection.
Were you not? I'm going to see what that.
There's an objection. What's the nature of the objection, Ms. Olson?
I'm not sure what she was referring to as failure.
Oh, okay. You don't like the
responses. I think I object to that language and that characterization. I don't think that's an accurate.
Okay, let me.
Okay, fine, Ms. Steve.
I understand her objection. If I might ask the question slightly differently rather than invoking a ruling by yourself.
Okay, state for the record that she was here during the entire proceeding today, and she was.
Yeah. So let me see. Okay, so you don't do UCT calculations. When this is a new program like this, Ms. Pereira, did you EPE, your department, did you select the idea of doing refrigerators, freezers, and air conditioning units? Was that something that the company sent up to Ms. Martin to calculate?
Yes, that's correct.
And did you as a company tell Frontier, Ms. Martin, how many of those units you expected to recycle each year?
I'm sure that was from the data that we've had from our previous, or maybe data that we had from Texas. I don't know for sure, but it was from our data, right? Or from our experience and what we believe we'll probably get.
Was a projection, correct?
Yes, that's correct.
The projection projects the unknown.
So when you
what we're trying to get at here.
Yeah, well, I'm trying to figure out why. Okay, why basically why didn't EPE propose recycling as a standalone program again this year?
I guess the main reason was from lessons learned and recommendations from the hearing examiner from the last case. You know, they asked me the question. We had reviewed other New Mexico utilities proposals, and that's what we did. We looked at PNM, and they do exactly that. They brought in their appliance recycling into the residential comprehensive program, and we thought that was a good idea. I mean, that would help with marketing and reduce costs, is how we saw it. I mean, it kind of like it would just help the program overall. But that was the main reason for bringing it into residential comprehensive, from a recommendation from the hearing examiner.
I do have that recommended decision as an exhibit, but I don't think that I will torture us both, either of us, with looking for that recommendation. Do you know whether those three measures, if they had been offered as a program, would be cost effective? Standalone program in New Mexico.
I do not.
And that's because the company didn't choose to ask Frontier to calculate those figures. Is that?
I don't believe we did. No.
And would you agree that if EPE does not know whether those measures would be cost effective on a standalone basis, the commission isn't going to know?
That's correct. I would imagine, unless they run their own analysis.
Okay. I'd like you briefly to look at the three, we're going to look at them again later, but at the three most recent annual reports on the program that you have. And these ones are out of order. And Mr. Lennon, they're also in this second email message that was just 3 attachments, because these are the large ones. It's exhibit 17, 18, and 19, which are the 2018, 2019, and 2020 company annual reports.
Give me a minute to get to those.
Yeah, I know everybody needs a minute to get to them, and they're big. I did the ever popular reduced size PDF, but you never know what you're going to get.
Mm-hmm. Can you tell me the time you sent that email?
Let me find it. It would be the one in between, but let me get the exact time for you. Hold on one second. Oh.
Stevens, you said 17. Your number. Okay, that was in the package that was signed, I think.
4:30. I think was sent at 4:31. It looks like received at 4:34 by myself. It was the middle one, but you didn't get the first one, so it's probably not the middle. Or you moved the first one, so it probably doesn't look like the middle one to you.
I have 422 and 441.
You don't have 434-ish, 431? Because that's the one that.
I'm sorry, I actually don't. I just don't have.
Well, let me shoot you this one too. I think it may go a little easier.
So there were four emails you sent with exhibits then?
No, there were 3 emails with exhibits, and then there was one that was. We could not change the notes, so both of them said second set, but they're. I did every.
I have one.
I hate to be pulling.
1 through 16. Okay, there's 1 through 16, And let's see what my next one is. I'm going to go through this carefully, 1 through 16. And the next one I have from you has number 16 again. It's still number 16. Oh, no, it's exhibit 20. Exhibit 20 through 20.
Oh, and you don't have 17.
The next one I have.
19?
Miss Stevens, you're breaking up.
The next one I have is actually exhibit 1 through 20. So no, I do. That's one that I simply do not have.
May I ask the other parties if, just anyway, Carrie,
They received it.
whether you did get those?
Let's ask them specifically. Mr. Black, did you receive that email, Ms. Stevens, first? Would you mind just pressing the forward button and send it to me right now, Mr. Black?
Yeah, I just did. I see now it shows as 24 megabytes. I don't know whether I did not get any undeliverables from people in this room or this Zoom room. So
Excuse me, I
so
hope I'm
assume
not speaking out of
I assume
order,
that they were successful.
Who was just talking?
I apologize. Hearing examiner is Christopher Dunn for staff. I hope I'm not speaking out of order, but I did forward that document to you again, as I had previously, just to see if coming from if it would make it easier for you to access.
Mr. Dunn, you must have a direct line to my computer or something. The other ones don't, but there's yours. It just popped right up.
Yeah, mine's just going real slowly.
17, 18, and 19, right there. Are you down the hallway with me here on the second floor?
No, sir, I'm not. Just doing my best to earn brownie points for staff,
Well, I understand. I hope you get a raise or something. Okay, now I apologize for all that confusion. And Mr. Lee, I guess all that talk is part of the record. You kept track of who said what when. Ms. Stevens, I now have those.
Are we good? Are we together now? Miss Brea, so I'm looking at CLC 17. Is that the 2018 calendar year report on EE programs that the company filed in June 2019?
Yes, the company filed on June 1st, 2019 for the program year 2018.
And if you would go to page 12 of the report, which is, I think, page 15 or so of the PDF.
Stevens,
Pages on the bottom, we have a cost effectiveness evaluation.
Respectfully, well, could you just proffer to me why this 2018 data is relevant to the issues in this case?
We're going to look at very quickly the UCTs of the residential comprehensive program
in 2018. And why is that important?
Because there really have not been, we can address this, but I don't think there have been many changes. I mean, they just the measures, but the program until this request to add refrigerator recycling has largely been, I don't want to over characterize it, so please, Ms. Brea, correct me if I'm wrong, but it's been fairly stable, I guess would be the word, in terms of its offerings and how it's been offered. Is that fair, Ms. Brea?
I didn't understand your answer to my question. I'm
saying we're going to look at this, just this one line of what the residential comprehensive programs UCT was calculated to see the trend and and see whether there's a relevance to adding these new measures. Because Mr. Hearing Examiner, we were not, as we discussed prior at the start of the hearing, because we do not have the actual UCT calculations from which one could run the, figure out what this program is with and without the new measures.
I'll let you ask. Go ahead, Ms. Stevens.
Okay, so are you with me, Ms. Brea, on page 12 of the 2018 report?
Yes, I am.
This is the these would be the statewide evaluators' actual verified results for all the programs in this table 9 on this page.
Just ask her what it is. What is it on page 12?
Yes, it is.
Table 9 on page 12. Can you just describe that?
Are you asking me to describe it?
Yeah, because, yeah, just describe what table 9 is.
These are the UCTs that we receive from the statewide approved evaluator.
And in that year, the residential comprehensive program had a 3.50 UCT, is that right?
That's correct.
And in 2018, the UCT was being calculated in the same way as it is now, is that right?
Yes, that's correct.
And now if we look at CLC Exhibit 18, would you confirm that this is report on its efficiency and load management programs for calendar
I'm sorry,
year
Miss Stevens, you're
2019?
breaking, Miss Stevens, you were breaking up. Would you confirm that this is?
EPE's annual report for calendar year 2019 on its energy efficiency and load management programs, which was filed on the commission with the commission on June 1st, 2020. Is that what it is? Ms. Pereira, that was a question to you. I know I was repeating myself.
It's hard to hear because your bandwidth is low, but
Is it
you're
really?
asking
I'm
if
so sorry.
If I'm looking at CLC Exhibit 18, our annual report that was filed in June 1st, 2020.
And if you go to page 2 of that energy efficiency report for year 2019, would you agree that this table 2 on that page is similar to, is basically the same as the table 9 in the previous page, report in terms of what it represents?
If those are the same UCT values from the evaluator, then that's correct.
Okay. And in so this indicates that in 2019, the residential comprehensive program as evaluated by the statewide evaluator was 2.36, correct?
That's correct.
And now if we go to Exhibit 19, do you agree that this is the energy efficiency program report the company filed for program year 2020 and was filed on July 16th, 2021?
I was filed on July 15th, 2020.
Oh, 15th. I see. I'm looking at the cover letter. This is the calendar year 2020 report, is it not?
It's our annual report for our 2020 program year.
And would you look at page 2 of the report, which is page 5 of the PDF? Are you with me?
Yes, I am.
And this is again the same analysis, UCT analysis, as we've looked in the 2 previous reports. Is that right?
Yes, that's correct.
So for that year, the M&V evaluator came up with a 1.93 value for residential comprehensive. Is that right?
Yes, they did.
And do you know what UCT the company is projecting for the residential comprehensive, including the appliance recycling measures for future years, specifically for 2022?
I'd have to go to it. That would be in Amy's exhibit in ADM1.
Well, we'll stop there. The city moves to admit the annual reports, and I know that they could be the subject of administrative notice, but I think that they contain a wealth of information that we'll continue to be using, and it might be convenient to have them in the file. But if your preference is administrative notice, that's okay.
Well, if you're gonna move to admit them as exhibits, I guess it would be 3 separate exhibits.
3 separate exhibits, 17, 18, and 19.
I think I'd rather
Ms.
proceed.
Correa verified what they are.
Administrative notice would, well, I think they should be labeled as exhibits. That's what I think.
Okay.
So if you're going to move to label them, we'll see if anybody has an objection to them being labeled and admitted. Mr. Simpson, do you have any objection to these 3 exhibits?
No objection, Your Honor.
Thank you. And what would be the number, pardon me, Ms. Stevens, we would number them separately. So what would be exhibit numbers?
17, 18, and 19 for 2018, 2019, and 2020, respectively.
For 2018, 2019, and 2020, they would be labeled as exhibits number 17, 18, and 19. They are the annual reports to the commission for the previous year's energy efficient use of energy rule compliance. So let me ask Mr. Black, do you have any objection to these being admitted as exhibits?
No, Your Honor.
Ms. Lynch, any objection?
No.
Ms. Olson, any objection?
Your Honor, these are publicly filed or documents filed with the commission that are publicly available, so I don't have any objection.
Okay, so there being no objection, they are admitted. I have a different reason. I'm all about convenience. And, I really don't like when we have to chase down papers. And, it might be publicly available, but if someone's going to read the record in this case, they shouldn't need to be chasing down documents. Anyhow, thank you. They are thereby admitted as numbers, CLCs number 17, number 18, and number 19 are admitted into evidence.
Thank you. So Ms. Correa, I'd like to move to kind of a much more broad area of questioning. As a matter of policy, not specifically the Efficient Use of Energy Act or Rule 17.7.2 NMAC, do you think that it benefits anyone for EPE to collect ratepayer funds and spend them on measures that are not over their useful lives, projected to have a net economic benefit?
I'm sorry, Ms. Stevens, you froze there.
I did. That's weird. Because, am I freezing, or is it? I'm seeing you freeze.
I heard her perfectly, Ms. Perea. I think the trouble might be on your end. I heard her. It was a very long question, but I heard the entire question. So unfortunately, we'll deal with it, Ms. Stevens. Ms. Perea apparently has a little issue with her computer. Yeah. If you could please restate the question.
Okay.
Thank you, hearing it, family.
So unfortunately, this is one I read out. That's why it's slow. So as a matter of policy, not specifically the efficient use of energy statute or 17.7 to the energy efficiency rule. Do you think that it benefits anyone for EPE to collect and spend ratepayer funds on measures that are not over their useful lives projected to produce net economic benefits?
As I stated before, we look at the program as a whole and look at the UCT as programs and not the individual measures.
And my question was, as a matter of, do you think that that's a good policy if you are possibly including measures that are not would not on their own pass the test?
Asked and answered multiple times.
Well, Ms. Stevens, like I said, I don't get involved in how you present your case or how you cross-examine this witness, but I have a concept, I call it, have you stopped beating your wife yet question. And there's really no good answer to that question. If you say, no, I haven't stopped beating her yet, that's a problem. If you say, yes, I have stopped beating her, you've just admitted to beating your wife. So you've asked, is it as a matter of policy, if it benefits anyone, which is a whole lot of people, I'd imagine it benefits someone, maybe an employee at EPE or maybe a stockholder of EPE. So I don't really see that it's a really helpful question. I understand you drafted it and wrote it out, but it doesn't really do anything for me. So I'll do an objection from the bench and I'll sustain the objection. Next question.
Okay. Let's look at your direct testimony at page 18. Oh, I'm going to have to stand up a second and adjust the Venetian blinds because I'm getting sun in here and I cannot see a thing.
By the way, folks, it's 1:30. No, it's 1:20. I'm sorry. So it's kind of close to a lunchtime break. Ms. Stevens, how much more examination do you have of this witness? Do you know?
Oh, quite a bit more.
Well, we might consider taking a lunch break right now, if you'd like, since there's going to be a lot more.
Yeah, that would be good. That would work.
Anybody else have any problem with that? No problem. Shall we take an hour? That'll take us to 2:20. And we'll still have a couple hours the rest of the day. I was hoping everybody could examine all the EPA witnesses, so we're moving a little slower than I expected. We only have tomorrow till 5 and we'll begin at 10 unless we decide to change that. I just want you guys to think about that during the 1 hour lunch break. Do we want to take less than an hour? No? No comment. I've got nothing. All right, we'll take an hour. We'll be back here at, well, it's actually about 58 minutes now. We'll be back about 2:20. I'll see you all at 2:20. Thank you. We are recessed.
Hi, how's it going? Gonna eat some lunch?
Mr. Black, you're still on, thank you.
You guys are amazing. Impressive.
Set an alarm.
Oh, that's what it is. Well, some other people must set the alarm for 5 after the time to return when they return late. I don't know how that works out. There was a lawyer that used to appear before me when I did this stuff for another state agency. And I swear the next thing that come out of her mouth was, the dog ate my exhibit. Because there was an excuse for everything. I don't know. At least I got a smile out of Miss Stevens. How was lunch? Good?
Yes,
All right.
thank you.
I'll show you what I ate for lunch. I ate a coconut candy roll. I like the Mexican candy because that was what was in my what was in my office and I didn't feel like going out. We lost Miss Olson. Well,
That's what I put in my son's Christmas stocking, this Mexican candy, because he loves it.
yeah, it's good stuff.
Just how bad is it for your teeth? It's
Teeth? Got teeth? I think I need 3 or 4 implants at last count. I don't really keep count anymore.
Oh, really? Really? Ugh.
Yeah, really.
Ugh.
Mm.
It's either the sugar or the stress.
Stress? What stress? No stress in this gig.
Judge,
Yes, sir, Mr. Lee.
I
Off
sent
the record.
I sent you all the CLC exhibits. I don't know if you received them, and I don't know if they're duplicates, but I just thought I would tell you.
Yeah.
You're just great. I actually have been ignoring my emails. But let's see. I got a whole bunch of stuff from you. 1, 2, 3, 4, 5. Yes, I got 5 things. And Ashley thanked me for announcing our job vacancy solicitation or whatever you want to call it. Ms. Perea, are you a lawyer?
I am not.
That's okay. Why don't you apply for the job?
Okay.
Mr. Lennon,
Yes,
Actually,
Ms. Stevens.
back in the day when I was staff counsel, we had our head accountant who applied every time there was a hearing examiner vacancy, and just was mad as can be that he was not seriously considered because he felt like he knew everything. And why do they think it needs to be a lawyer?
So what's his email address?
I don't know. he might come out of the woodwork.
I really think this job does require one to be not only a lawyer, but a lawyer with trial experience and hearing cases experience, if possible, quasi-judicial or whatever, because it really does help sometimes. It's good to know when lawyers are trying to bamboozle you.
I'm
We're
saving
not going to take
myself-
that personally. We're off the record, right?
We're still off the record, right?
I'm saving myself for federal court judgeships.
Good move. Well, you've heard enough cases that you have a pretty good idea.
My son sees those, my 23-year-old son sees those, the federal magistrate renewals that they come through fairly regularly. And he actually checked once, and when he discovered that a federal magistrate judge in Las Cruces makes like $300,000 a year, he says, well, why don't you apply for that, Mom? That would be the perfect retirement job. $300,000 would go really far in Las Cruces. I said, well, somebody gets in there and they stay in that job until they maybe get to be district judge. But yeah, federal, I hear you, Mr. Court Reporter, federal's the way to go.
Amen.
I worked in federal court for 25 years.
Ah.
Oh, wow. Impressive. Well, I enjoy talking with all you guys. It is kind of a
go back to the hearing.
highlight of my whole day. But it doesn't say much for my day, does it? I think we should go on the record. Are we ready? Mr. Lee, please put us on the record. Thank you, everyone. And we've just returned. It is time is 2:25. I've been talking with people about none of the merits of this case whatsoever for about 5 minutes or so.
Absolutely.
Yeah, it's been kind of nice to not have to talk about the case, but now we need to continue. When we stopped, we were in the middle of cross-examination of Ms. Perea by Ms. Stevens. We'd certainly like to move the case along, if at all possible, Ms. Stevens. I would appreciate it. Thank you. Continue.
Good afternoon, Ms. Perea. I'd like you to turn to bottom of page 17 and to page 18 of your direct testimony.
Okay, page 18.
Yeah. So you're explaining your request for approval to modify your proposed budgets for plan years 2023 and 2024. First of all, the first sentence is based on actual 2021 and 2022 revenues. Can you explain how that would work?
That would, for us to modify our programs, that would be, I guess that has to do with the, the things that we're seeing right now regarding, the COVID, the pandemic, and then also, the codes that might come into play. I mean, different things that change, unknowns that we're not seeing, that are unknown to us right now.
So and this is actually, there's several, this paragraph here has several, I think separate changes that your potential changes that you're discussing, but let's start with just the one that's based on actual 2021 and 2022 revenues. Is that something like the reconciliation that the company is proposing with the $900,000 balance in this case, or is it something different? I think. Has Ms. Perea frozen?
So, no, I'm not.
Okay.
I apologize. I'm reading the question above.
Okay.
And so your question is, why are we proposing to modify our programs based on the revenues? Is that correct?
Well, my original question was, how are you doing that? And I was trying to prompt you and see whether it had to do with that notion of reconciling spending to match revenues. And I just want to know what you mean by this, and just give us an example, I guess.
Well, that would be so based on actuals. Well, I think it has to do with the revenues that come in, right? I mean, I guess because the goals, the 2025 goals, they've increased, and we're not sure if we'll be able to meet them, but and I guess just the unknown, because we don't want to be in that predicament where we over or under collect, right? That's not a good thing.
So are you suggesting in this first sentence about the 2021 and 2022 revenues, are you suggesting that you will make adjustments without coming back to the commission, or by filing a motion with the commission?
I think it's, we're on line 4 where EP proposes to shift funding among programs and to adjust program year expenditures within the 10% authorized by the rule. I mean, are you asking about that part of it? It's kind of
I'm asking whether that first sentence whether we'll go sentence by sentence. I'm wondering whether the first sentence is tied to the 10% adjustment things built into the rule, or whether it's a separate statement or request.
That would be separate.
Separate. So if it's separate, can you explain to me again what it is? Well, would you, if it's separate from that, would you go to the commission? I guess is a simple way of asking the question.
Well, I think according to the rule, I mean, we're allowed to adjust our programs within 10%, right? Which is authorized by the rule. But so then so then that's one thing, right? With required program funding, program year funding requirements. So that 2021, that one, it is based on that. So right now, we don't have the latest, we don't have the final results of the 2021 revenues. Those numbers we don't have those yet. And so we don't know where we're going to be on that.
Are your proposed budgets for any of the 3 years of this program dependent on the 2021 revenues?
Well, this whole plan is based off of what the year 2020 revenues. So we don't know how we're going to fare in 2021.
And going back again to my question, that first sentence, would that be an adjustment? Well, I think you said that the 10% does apply, but would the 10, if you were beyond 10%, would you come back to the commission? Or are you requesting somehow prior approval here?
No, we would have to come back to the commission, as I understand.
Hearing example, Lennon,
Yeah.
I apologize, I'm having a hard time squeezing an objection in, but this seems like legal questioning.
No, I don't know that it's legal questioning, but I really don't see where you're going, Ms. Stevens. Like I said, I'm not going to try the case, but I just was wondering what you're trying to prove by this line of questioning.
It will come together eventually. What can I tell you? I don't necessarily.
Maybe
Let's move on to, may I go on? I'm sorry.
Yeah, overall.
The next sentence, Ms. Perea, which you alluded to, within each program year of the EELM plan, EPE proposes to shift funding
with each program year of the
approved EE/LM plan. EPE proposes to shift funding among programs and to adjust program year expenditures within the 10% authorized by the rule. Do you mean that the funding amongst programs is limited to a 10% shift, or are you suggesting a more freedom to shift funding amongst between programs?
So we're requesting to be able to adjust funding of each program within the portfolio, not to exceed 10%.
So you could move. So one program could end up being 10% bigger than, have a 10% higher budget than you've put down in this plan. But if it went to 11%, you would come back to the commission for permission? Is that what you mean by 10%?
Well, we wouldn't be able to make any program shifts more than 10%.
More than 10% of the program, or more than 10% of the entire portfolio?
Of the entire portfolio is how I understand it.
Next question.
Is it, what approximately what is 10% of your budget? Very approximately.
Well, if you, let me see, let me look at that. I have to go and look at my exhibit AGP 1.
Mhm.
So,
Let's let her answer. AGP 1. Go ahead.
I'm sorry, so it'd be AGP 2.
AGP.
It's a 3-pager. Which year are we looking at? Or it wasn't asked per year, was it? What was it for all years? This is the proposal.
Yes, that's correct. So it'd be 10% of the 6,000. Well, so then I'd have to do the math, right? Because then, let me see. Sorry, let me switch this on. Okay. Yeah, imagine it would be 6,000 of the total program costs of our portfolio, right? So it'd be 10% of that 6,226,213.
So that would be
I'm
around
sorry.
$600,000?
I'm sorry, 6 million, the number?
I'm sorry, 6,226,213.
Thank you. The question, please?
10% of that would be roughly $600,000. Is that right?
That's correct.
And looking at that, stay there on exhibit AGP 2, and I think we're on page 1, right? If you took $600,000, if you had $600,000 and you added that to many of the programs there, you would be more than doubling, in some cases, even tripling the size of the program. Is that correct?
Well, if we chose to put it in one program,
Yeah.
depended on the program.
Is that right?
The math speaks for itself, Ms. Stevens.
Does the company believe that shifting funds in that having the freedom to shift funds that to that degree so that an individual program is much larger or potentially much smaller is consistent with the intent of the commission in approving the plan?
I believe that that's within the rule that we are allowed to shift within 10%.
Okay. Let's say then, could you just plain, if you were under collecting, could you just plain cancel the Energy Smart program, which is only $225,000?
Are you asking if we would be able to cancel the program?
Yeah.
We would not, as in terminate it?
Terminate. Well, stop, maybe keep the program, but not fund it.
I would believe that we would have to, I mean, that's termination, and I can't answer your question. I don't know if that's something that we would have to ask the commission.
Next question.
And if you cannot, and your EP's supervisor of energy efficiency, if you cannot articulate the standard by which a decision to come back to the commission should be made, doesn't that mean that you could make changes that will happen after the fact?
Ms. Stevens, you're
The commission will
basically
never know till after
testifying
the
instead of cross-examining. And I prefer that you didn't do that.
Mr. Hearing Examiner, I'm objecting to this question as well. It sounds like Ms. Stevens is asking Ms. Perea to interpret the statute and the implementing regulation and what the law is requiring for when commission approval is required and when it's not.
Ms. Stevens, I most respectfully sustain the objection and ask you to move to another line of questioning.
Okay. Let's go back. Let me hold on. I got your testimony upside down, I think. Oh, I lost you altogether. Oh, I made it. That's my problem. So if we could go back to page 19, 18. Sorry, it's just. Back to page 18.
I'm sorry, Ms. Stevens, what page?
Back to page 18. So when you're talking about modifying the budgets to align,
It sounds like the same line of
it's
questioning.
probably the same line of questioning. And yeah, okay, no, hold on.
You know,
For some reason, I will try to figure out where to move on to. My screen is going a little weird here.
while you're doing that, if I were trying to prove something like I would refer to historical data and say, ma'am, isn't it true that on year A or on year B, you increased one of the line items by
Well,
10% of the.
Mr. Hearing Examiner, we were going to go there. We will get there. Oh, that's what we'd like. Let's look at exhibit. Let's look at exhibit 19, the 2020 annual report, Ms. Brea.
What's the number of that exhibit, please?
Number 19.
Oh, your number 19.
My
Okay.
number 19. It's the annual report that was in the batch that I sent you that had 3, or that Mr. Lee sent you that had only 3 attachments.
Right. They are already admitted as evidence.
Yeah, it's already admitted. Page. Let's look at page 11 of that report. And this is 11 at the bottom of the page. Do you see a table 10 budget variances?
Are you in exhibit
I'm in
19?
19, I'm on page 14 of 168. If you're looking at the PDF, at the bottom of the page, it is page 11 of the annual report.
All right, thank you. Let me see. And that is table 10, correct?
Table 10.
Okay, I'm there, thank you.
And let's look at some of those actual budget variances. For New Mexico Energy Saver, the low-income program, the company exceeded its planned budget by 76%. Is that right?
Yes, that's correct.
And for the Living Wise program, you came in at 56% under budget. Is that right?
Right.
And for the 2 load management programs, they were significant. They were under budget by 30 to 40%. Is that right?
Yes, that's correct.
The company at no point sought any kind of commission approval for adjustments, did it?
No, it did not.
It decided how to spend the money available to it. Is that right?
I'm sorry, what was your question?
The company decided, how did the company make these sorts of judgments?
This is historical data. I don't, this is just showing the compared, the approved budget and the actual, and then what it came out to after an analysis at the end of the year. I'm not sure. I think we're comparing apples to oranges. I don't know that commission approval for a variance from the planned budget is necessary. Matter of fact, this data is, it just doesn't, this is not the type of, this is showing the variance. It's showing how reliable their proposed budgeting was. It's not showing whether the commission approved that their actual varies a certain percentage from their budget. So I'm really, I think we're saying this apple is much more red than the orange. And, of course, an apple is more red than an orange. And that's what we're looking at here. no one plans the variance. That's why it's called a variance. That's my
But
point.
okay, Mr. Shearing, I will ask Ms. Perea the ways that the company can manage the variances. And I know that 2020 was the COVID affected year, Ms. Perea, so I understand that that's a consideration here. But once you have a program in effect with a budget, does the company limit the number of offerings? If the demand for a program is higher than you budgeted for, does the company limit the offerings in any way in any of the programs?
I think it all depends on the program.
And can you give us an example of programs that do enforce some sort of limits?
The commercial load management has a cap.
And in this example, though, what we're looking at here, commercial load management came in much below budget, but you're saying that that's one that has a cap. How about, I mean, do you ever say no to specific measures because you've hit some sort of expected threshold cap?
For the other programs, you're asking me in general, and I would have to say, I think it all depends on the program again. So my answer would probably be no. But it's a depend question. But I would have to say, yeah, it's a depend question because Score Plus, we put caps on there as well at times. So yeah, I can't say that. I can't answer that. I have to think about each program individually, but the Score Plus, we do put a cap on as well.
Okay. How about commercial, the ones that have more flexibility, commercial comprehensive? Do you put caps on that?
Let me see. That could, yes, we could actually, that would probably, it has a potential for putting a cap on it as well.
And residential comprehensive, which also has a lot of measures?
Probably not. Since these are for residential customers, the incentives aren't as high as what we see in commercial programs.
Energy Star New Homes?
We haven't had to put a cap on that program, if I can recall, in the history of of that program.
And the New Mexico Energy Saver program, do you impose any? I see that in this year you went well over the budget, but in doing that, did you shuffle the available measures in any way, or did you just give people everything that they were eligible for?
We always give people what they're eligible for. I'm not sure what your question is there, but that one, we had really great success on that program. And that is a low-income program, so we do not put a cap on that one at times, and we didn't this time because of the year of the anomaly of this year, the pandemic year.
And did you just say, I'm sorry, did you just say you have at times in the past put caps on that?
On Energy Saver? I don't
On
know.
Energy Saver?
No, on Energy Saver, I think in years, we do not. I mean, this was, usually we barely meet the goal on Energy Saver program or just barely surpass it.
So you don't have like a number of households that you aim to work with? Or do you work to the number of households or to the number of dollars that you have available?
We try to get to as many homes as possible in that low-income program, because that's where there's a huge need, right, for low-income customers. They're the most they need the biggest help. I don't want to say that, but I think that's, referring to Lisa's testimony, that is a population that we really need to try to help, and that's going towards the rules, right, that by the commission.
I appreciate that. Let's change to an entirely different, quick, I think hopefully easy question. And this has to do with the modification that you I'm looking at the modification that you made, the footnote on AGP 2, the annual amount of internal administrative expenses. That's it's also on page 19 of your testimony. Yeah, lost again. You refer to the internal administrative cost on page 19, but the number shows up on the revised exhibit. Sorry, on the revised exhibit AGP, something is weird with my computer. The footnotes about the administrative expenses include EPE's internal administrative costs of $211,956 are covered through base rates. What does that number represent?
As we had, that number represents EPE staff benefits and salaries times the New Mexico what is it, percentage that was provided to us by Adrian Hernandez.
And can you explain to me why that number changed from the previous AGP? It's not much, but how and when that changed from the $227,000 roughly that you have on AGP 1 for 2021?
That's just different staff from that number, that from AGP 1, that administrative cost of $227,942 was recovered in base rates. That number was due to different staff. That is not, we had large turnover in our department since I became supervisor. So that's the reason for that change.
Okay, thank you.
You're welcome.
Now, my screen just wants to go gigantic. So let's turn out just a few questions about the individual programs that we haven't already discussed. With respect to I'm looking for the citation, but for some reason, I apologize, everybody, my screen wants to go to 6,400%, which is not really working too well. So let me try to make it stay. So in the individual programs that you discuss, what's a smart light bulb, Ms. Perea?
Are you referring to the smart LED?
The smart LED, yeah.
What is it?
What is it? What makes us an LED smart as opposed to just a regular LED?
The smart LED has Wi-Fi connectivity, Bluetooth. You could speak to it through Google or Alexa. It has various temperature settings, right? So different brightness, and you can control it remotely, right, through your cell phone.
So if I'm a student in the proposed FutureWise program and I get a smart light bulb in my kit, can I just screw it into a socket in my, on my desk table because I'm a high school student and make it do all sorts of wonderful things with my cell phone, or do I need additional equipment?
Well, I mean, as I mentioned, you can use it. It connects to various items, right? A Google, Alexa, cell phone, your PC, I would imagine. So you connect it to several different what do you call it, apparatuses.
The bulb itself connects to my phone, or do I need some sort of a special socket or something?
Oh no, the phone it's the bulb itself. You don't need a special socket.
And will FutureWise include educational material about how and why to use that smart light bulb?
I would imagine it would, but
would you
I don't know for sure, right? Don't know the answer for sure because everything's online, right? To save paper, it probably could be a link that they provide. I mean, I'm not sure what you're asking exactly.
Well, what I'm asking is if we would look at CLC exhibit number 6, please. That's open. I don't necessarily want to go line by line through this, but the gist of this was, if you look at the answer to B, which asked about that asked about specifically about residential lighting, but if you look at the answer to B, it says that there's no educational material or customer support planned at this time regarding the smart LED products. And I just wonder whether which programs, including marketplace, residential lighting, and smart students are going to attempt to teach customers how to use this new technology.
So the answer to CLC 1-7, letter B, there is no educational material customer support plan at this time because this program hasn't been approved. But if it is approved, there'll be a link. I can't tell you there'll be a brochure or what it'll be exactly because we haven't gotten approval for this. But there'll be a link regarding the marketplace. I'm not sure. I mean, there's depending on what the product is. There may be links as well. I mean, it's all the information is on Google. So I'm not sure if you're asking if we would provide additional information or what you're asking.
The company is proposing the plan and the commission is going to maybe approve the plan or maybe not approve the plan. And I guess we're wondering what the plan is. Do you see what I'm getting at?
But so which can you, what,
it's a chicken and egg problem.
What program are you talking about?
Well, let's talk about marketplace.
Okay. Yes, so in marketplace, depending on what the product is, that there will be material that goes out with them, depending on how complicated it is. But we do a lot of outreach and we talk to our customers. I mean, so I'm not, so I think that would, and everything's on Google. I mean, so, you know, we would probably provide a link if it's very complicated, if the product is very complicated.
Currently, for the New Mexico jurisdiction, are you using marketplace for smart thermostats under the residential load management program?
I'm sorry, can you
ask
your question again?
presently, under the present programs that were approved in the last cycle, you are using Marketplace to sell smart thermostats to New Mexico customers. Is that not true?
We're referring to that as a microsite because it's not a full-blown marketplace.
And does that microsite include educational material, or is it just sell products?
I believe it has educational material in there.
When you go to that site, or when you go to the proposed marketplace, you're suggesting specific, well, at least in the commercial, specific rebate amounts. Is that not true? Or let me put this better. For which programs through the marketplace have you identified the rebate amounts presently?
Can you ask your question again? For which program?
For which measures in the marketplace program have you identified as part of your application the amounts of rebates or cost savings that you will offer to customers?
So you asked me the cost savings and then the incentive. We have not, we do not have incentives in place for the measures that we will be offering.
If you don't have the incentives in place, how did you determine whether the program is cost effective?
That was through, that's the part that Amy Martin talks about on how she calculated the UCT.
But I thought that maybe I didn't ask the right question at the start of our discussion. I thought that one of the things that the company proposes is the incentive levels or rebate levels. No?
Not at this point. We do not have the incentives.
So are you, if I ask Ms. Martin about that, will she be able to tell me what incentives? If you're saying they don't exist yet, but our understanding is that to calculate the UCT, they have to exist. I'm sort of lost in this conundrum. Can you help me?
So I should correct myself because it's more than likely that we will still continue the $600 incentive for evaporative coolers for residential customers and $700 for low income. But the detail as to the incentives that Amy calculates are based on past participation and projections of participation, right? And what we've seen in the past.
There's been no marketplace in New Mexico in the past. I said, what past participation are you looking at?
That'd be a question that Amy would have to talk to address.
But Ms. Prea, you told me earlier that you're the one who gives Ms. Martin the projections or the projected participation.
Right, yeah, but I'm not exactly sure because we've given her a lot of data. I'm not sure which one she actually used.
If you don't know, how is anybody at the commission going to know?
Objection, mischaracterizing witness testimony. Ms. Perea has already answered the question.
Overruled. You can continue the interrogation, please.
Do you remember the question?
I do not.
It was if you can't tell us what that information is, how is the commission going to know? How are anybody in this room?
So your question was on the marketplace, is that correct?
Yeah, we're talking about the marketplace because it's new.
Okay, all right. I apologize. Okay, so for the marketplace, we did look at the Texas data and made the assumption that as I make note in my rebuttal testimony, that we made the assumption that we would get that participation rate was made on our belief of what we currently see right now with New Mexico customers, where they come to our website a lot more than Texas customers do, because our rebates, we offer rebates online, and our rebate forms are online. So they frequent our website more often than Texas. So that's kind of some of the assumptions that we made, but we provided Amy Martin.
So does that mean that the data that you provided to Amy Martin about the marketplace program in New Mexico was more optimistic than your historic experience with the program in Texas?
I wouldn't say it's more optimistic. As I stated in my rebuttal testimony, it was based on the frequency and the amount of traffic that we get in New Mexico compared to Texas.
What are the online rebates that New Mexico customers presently are getting?
They have access to ceiling insulation, windows, and let me see, and cool roofs. They can have get rebates on air infiltration, duct sealing. I mean, to give you an example, did you want me to list all of them?
Well, it's interesting that you're talking about things that sound like they're part of residential comprehensive, maybe, that they're actually building improvements. Is that right?
The measures that we offer?
The ones that you use, did you use the online rebates for?
Yes.
Okay. I think that the idea of selling light bulbs or thermostats or things that you're going to put in the mail, somebody's going to pay for and you're going to mail is a little different than that. Do you have it? Is there something that you're currently doing via the website that's sort of analogous to what you're proposing with Marketplace?
So the Marketplace would be items that we would be able to ship to the customer, where our residential rebate program is things where they either hire a contractor or they can do it themselves and then submit the rebate program. I mean, submit their form online or mail it in.
And if I were to go online under the proposed program, what would I find? The proposed Marketplace program. What, I know that you said it isn't final yet, but we need to know what's in there somewhat.
But you're asking what you would find if you were to go into the proposed Marketplace?
Right, as a customer.
So if I can refer you to my direct testimony, I state that in my testimony as to what we intend to have on the Marketplace. If I can direct it to my testimony.
Which place in your testimony? Because I want to just walk it through.
We have 2 more witnesses to get to in the next hour and 50 minutes.
Well, then we will move on. And if it's in her testimony, it's in her testimony. Let's talk about your response or to the question of the city's issue on lighting, Ms. Perea. I understand, I see from your qualifications that you're certified as an energy engineer and things like that. Is that right? I forget what the specific certification was, but you've got a lot of background in that area.
Yeah, certified energy manager.
In your direct testimony, you did not address potential changes in federal law or regulations regarding general service lamps, GSLs, is that right?
That's correct.
At the time that you prepared that testimony, were you aware of indications within the Biden administration that there were likely to be changes to reverse what the Trump administration had done, as Ms. LaRock talks about?
Yes, it was.
And it is your, and you testified earlier that you did not act on that because you felt that the commission had said no in the last time. Is that fair?
I'm not sure if I stated it that way, but if you're wanting me to give you the reasons why we didn't do it.
Well, you did give me the 3 reasons, and one of the among the reasons was that the commission had, not acted on prospective changes in the last case. Is that right?
I believe that's correct.
Since this case was filed, to what extent have you kept up with the ongoing developments at the Department of Energy?
Well, I'm aware that it's in litigation or it hasn't passed. So, we filed this 3-year plan in July. We've been working on it since the beginning of this year. And so we went forward with it since it's not in effect. We created our plan as if that has not happened yet, which it hasn't. And so, and residential lighting is in a TRM, and so that's an eligible measure to move forward with. The program is cost effective, and so we included in our plan portfolio.
If you would turn to your rebuttal testimony, this is when you rebut Mr. CCA witness Justin Brandt's testimony, and page 11. See, you summarize his concerns at page 11, and it's page 14. Page 14, lines 14 to 17. Your testimony is, if new legislation is enacted, EPE will work with the statewide evaluator and other parties to determine the appropriate updates to not only this program, but our entire program portfolio, since the proposed legislation could also impact EPE's portfolio. And my question to you is, when would that happen in terms of the 3 years that you're putting on the table, in this case? How quickly would that happen in your estimation?
I don't have a good estimation for that. I don't know.
Do you believe that what you're saying there, or what you were thinking when you wrote that testimony, is that we could in fact be doing another case like this before the 3 years are up?
That's possible, yes.
And could it be even, in a year or so or less?
And that's anybody's guess. I'm sure everybody can agree with that. We have no idea.
Would you look at exhibit CLC 7? I think we had that open earlier. Now I've lost it, pardon me. CLC 7. Oh, actually, we didn't have this. I'm going to ask you to look at your answers to part, this is about the triggering of the backstop, and we did have this open earlier. I don't think it was admitted though.
I don't
So,
understand what you're saying, Ms. Stevens.
yeah, we're in exhibits, CLC 7, it's the response to CLC interrogatory 1-9, and the answers that have some substance, we've already talked about, but I just want to go back and ask Ms. Perea, now that we've talked about the law changes, whether, and what you just said about the evaluator, that it's in the TRM, is it your position, is it the company's position that until the federal regulations change, the commission does not have the discretion to reject EPE's proposed lighting programs or measures?
I'm sorry, Ms. Stevens, you directed me to CLC, and yet you said 1-9, but I think you're.
Oh, it's CLC Exhibit 7, it's response to 1-9.
Oh, so you're in Exhibit 7?
Exhibit 7.
Okay, I'm sorry. Okay, I'm sorry. And what question are you?
The answers that really have some substance to them, B, D, and H.
Okay, I'm sorry, go ahead.
Okay, so the question was, and I'm looking at this discovery response plus what you just said about the New Mexico TRM. And my question is, does the company think that if something is in the TRM that the commission, and you've used the term eligible because it's in the TRM several times in your testimony, do you think that if it's in the TRM, the commission basically must approve it if the TRM indicates that it's cost effective?
The evaluator is contracted by the PRC, so the work that the evaluator does and creates the New Mexico TRM, this would oblige us to work with the measures that are in the TRM. So,
does every measure in the TRM, is it your belief that every measure that's in the TRM, if it works, pencils out for a particular utility, that the commission should approve it?
Objection. I don't know what Ms. Stevens is asking, and I'm not clear what pencil is.
Well, I'm not aware of the relevancy, and and it's speculative and hypothetical questions have very little value to me for evidentiary purposes and for persuasiveness or probative value is what I'm trying to say. They just don't have much probative value, and I'd rather have questions that are to.
Well, I'll move to admit CLC 7 and move on if that would be.
Any objection from Ms. Lynch?
No, but I do have questions for Ms. Perea that
Okay.
I'm waiting on asking.
Thank you for letting me know. I was wondering that. Mr. Black, any objection?
No, sir, no objections.
Will you have any questions for this witness?
Staff will have no questions for this witness.
You don't really need to decide until it's your turn to examine, but I'm just asking for time management purposes.
Mhm.
Mr. Simpson, any objection to the admission of this document?
Your Honor, no objection, and I do have about 3 questions.
Okay. Ms. Olson, I take it you're going to rehabilitate this witness, right, or try?
Hearing examiner Lennon, at this point, I don't expect to have much, if any, redirect.
Okay. And you have an objection to the admission of this document or none?
I have no objection.
All right, so there being no objection, this will be admitted. It's marked as CLC exhibit number 7. Is that correct, Ms. Stevens?
Yes.
So number 7, CLC number 7 is admitted into evidence. So please continue.
Thank you. Regarding the residential lighting program, Ms. Paya, I need to lead you to the discovery response, but let me just ask you flat out. For this particular plan, EPE did not evaluate the market saturation of LEDs, did it?
I don't believe we did. No, we did not.
Do you believe that is the last market saturation, was your last evaluation of residential lighting performed on the 2018 plan?
I'm sorry, if what was performed?
The last MNV evaluation of the residential lighting program, was that in the 2018 year?
I believe it was.
Yeah.
But
so, we'll just, and that would have been included in the 2018 report that we've already admitted into evidence, is that right? It's CLC 17?
So I think when you say that, I think you have to be careful. You know, you're talking calendar year, program year.
Oh, okay. I'm talking program year.
And so the evaluators evaluated it for program year 2018.
Mm-hmm.
And so then it was in the 2019 annual report.
Right, before the plan. And does that mean under the 3-year rule that it's going to be evaluated again based on this 2021 experience?
Yes, I believe that's correct.
I'm zipping some risks. Okay, let's go quickly to your rebuttal. I'm really almost at the end. To your rebuttal testimony, Ms. Perea, and it is, oh, there's too many things open here. On pages 4 to 5 of your rebuttal testimony.
All right.
I understand that, that your attorney objects to asking questions about legal questions, and probably I will object to legal questions about, but this is very specific. At the bottom of page 5 onto the top of page 6, basically it's the line on the line 1 and 2 on page 6. You make the statement that the latest rule changes brought the rule into alignment with the Efficient Use of Energy Act. And this is in regard to the questions of measure or program. And I would like you to tell me, first of all, tell me if you can just describe what the changes are, or else I'll ask you to look at that rule, because I don't know what you mean, and obviously you meant something. Could you just tell me, so would you please just tell me?
Questioning on specific rule changes, I think that's a legal issue. If Ms. Stevens wants to ask the witness what she meant in the language she used in her direct testimony, I think
that's,
yeah, Ms. Olson.
That's what I mean. What do you mean by this? The latest rule changes brought the rule into alignment with the EUEA, given the context of the question, which is Ms. LaRocque's testimony about measures versus programs.
Which page are you on?
I'm on the actual cited, the sentence we're talking about is lines 1 and 2 on page 6, but the question and the context is the question on page 5, at the lower half of page 5.
I must be having a different numbers or something. Are you looking at the numbers on the middle of the page on the bottom?
I'm looking at the number on the bottom of the page, and It's also pages 7 to 8 of 32 on the PDF. But we did have different PDF documents, which was the problem this morning.
I don't have PDF numbers. Oh, I
Okay.
see the PDF numbers. Okay. And which PDF number is it?
So it's 7 is the question of 32 and 8 is the answer. Very top of 8.
And I apologize for me being slow with the technology. Now I'm there. Okay, so she's definitely, was your objection that she's asking for a legal conclusion, Ms. Olson, or an opinion?
No, my objection was Ms. Stevens stating that she was going to show Ms. Perea the rule and have her identify changes from previous iterations of the rule. I have no objection to her asking what she meant by a statement.
And I think I asked that, said if we need to look at the rule, but yeah, I'd like her to just explain what she meant by that sentence.
Okay, and let's try to be kind with each other and not interrupt and wait till somebody finishes talking before we respond. Okay, you can ask your question again, Ms. Stevens.
Okay, so what do you mean about the latest rule changes brought the rule into alignment with the EUEA in the context of this question to yourself?
Just the fact that there was a lot of opinions that didn't agree with each other, or and I more than anything, the rule and the EUA weren't clear in how they were written when referring to programs and measures and cost effectiveness.
And you feel that it's now more clear?
Yes, I do.
Okay, let's see. Page 6, I guess we're right here, page 6 of your rebuttal testimony. You say that Ms. LaRocque's arguments aren't about the UCT analysis are not internally consistent. Is it your understanding, Ms. Perea, that the EUEA and the Commission's rules treat low-income programs differently than other programs?
That's a broad question. I mean, it's
okay. Well, let's look at the specific part of your testimony here. I'm looking at lines 13 to 14 on page 6
of my direct testimony.
Of your direct testimony. Oh no, your rebuttal, where we were still in the same page, actually the same page of the rebuttal.
Okay, page 6.
Yeah. And actually starting at line 9, you're quoting from Ms. LaRocque's testimony, is that right?
Yes, I am.
And I'm just wondering about the text that you removed with the 3 dots, the ellipsis. Do you recall what that text is about?
Oh, what I left out?
Yeah, what you left out. Do you remember what you left out?
I do not. I have to go back to her testimony.
But did you deliberately leave something out?
Yes.
Okay. I'm flipping through here. Page 20 of your rebuttal testimony, Ms. Perea.
Okay.
This actually it's page 21. The question is on 20, but the answer is on 21. and you testify that this is lines 8 through 11 about EP is continuously improving the programs. Is it fair to say that based on what we've talked about the residential lighting and the GSL requirements, that when you when you make changes to improve programs, you're focusing on historic data as opposed to forward-looking information?
You referred to my testimony on page 21. And what I mean by that statement, that we're continually improving our programs, this is due to the results that we get from the EMB evaluator. You know, as I state there, that regarding their new free ridership values that they see, that they've calculated, their new net to gross values and recommendations. And so that's and then of course all the industry standards and codes are the baselines for some of these measures increase. So then that you know, reduces our savings for measures. I mean, so that's the continuously improving the programs. I mean, that's something that's out of our control, right? Just what happens. Well, with the MMB evaluator and industry.
Let's use codes as an example as opposed to light bulbs, because we've done enough of that. If a code is adopted and is going to take, a building code is adopted and is going to take effect in year 3 of your 3-year program, how would you incorporate that into your program planning?
If it was to happen in year 3 of our 3-year program, that would probably not come into, I mean, are you talking the beginning of the 3-year or the end of
the last of the 3 years, the third of the 3 years?
And it would probably not come into effect into our program, but again, that's up to the evaluator. The evaluator would make that decision.
Are you talking about the evaluator who evaluates your person, you know, the company's own programs after the fact, or are you talking about the evaluator's role in producing the TRM?
I'm talking about the statewide evaluator, commission approved statewide evaluator.
Right. But we're talking about how to plan a program going forward. So my question is, if you propose something, but you knew that the code was going to change in year 2 or year 3 of your program, would you go ahead with the same program, or would you modify it in anticipation that yes, there are changes in the offing?
We would not make the changes in anticipation of a program. I mean, of a new code. Not until we're directed by the evaluator. We work very closely with the evaluator, so the statewide evaluator.
And is that, when you work closely with the statewide evaluator, is that in terms of the post hoc, you know, after the fact evaluation of your programs, or do you work with them also on the annual updates to the TRM?
So both.
And when you're just saying that you would, in this kind of circumstance where there's a large change, you know, I'm talking about residential lighting, even if I'm asking you about the codes context, if the change is known and is going to take effect prospectively, how would that be reflected through this reliance on the MNV evaluator?
Again, that would be up to them, and it depends what time of the year, and it depends on various variables, right? I mean, it's just not a one-stop decision that they make. It depends what you're talking about or what the measure is.
If you could go to page 22, or on 22, you also No, it's not the place. Out of scope. Yeah, on page 22, you talk about your communications with Ms. LaRock, and on lines 5, and you attach her recommendations as your exhibit AGP2, correct?
Yes, that's correct.
And then but you also testify that EPE did receive some non-binding recommendations from CLC. However, after discussing them with Ms. LaRock, she admitted that her non-binding recommendations were, quote, out of the scope of energy efficiency, unquote. I would ask you to look at CLC exhibit number 26, please. Are you with me?
Yes, I am.
And is this the correspondence between yourself and Ms. LaRock about the revision, the city's proposals?
This is a conversation of her providing them to us, but it's not our conversation.
That phrase that you put in quotations, where did that come from then?
When we spoke.
And that's your recollection of this statement?
Yes, that's correct.
And you recollected so clearly that you put it in quotation marks.
Which page are you on? I have 9 pages.
No, it's. I'm going to just ask to admit this. She said this is the lead up to an oral, I guess, a telephone conversation or a person-to-face. Nobody does to face-to-face conversation. Was it a phone conversation, Ms. Playa? The meet or a Zoom meeting or something that subsequently?
Yes, we met afterwards. As I stated in my direct testimony, I met with CCAE after they submitted their non-binding recommendations, and once CLC submitted their non-binding recommendations, I met with them as well afterwards.
And meet in this day and age is a phone conversation or a Zoom meeting or a face-to-face?
It was a virtual meeting.
Virtual. And that's so of Ms. LaRock, right? Okay. This one. Go back to your rebuttal. If I can find it. Page 24, line 19 through page 25, line 2. Would you read that out loud?
Which exhibit, please?
Oh, it's exhibit 1, her own rebuttal testimony.
Oh, okay.
Exhibit 2, pardon me. EP exhibit 2, Ms. Playa's rebuttal.
And I'm sorry, Ms. Stevens, what line numbers?
Page 24, line 19, onto the next couple of lines and following page.
Okay, so reading from my rebuttal testimony, page 24, line 19. It should be noted, EP gathers information pertaining to the tracking requirements of the TRM. EP has previously stated to the City of Las Cruces, gathering additional information would be a cost burden that the City of Las Cruces would have to pay for.
Does the company actually obtain information about the programs in the level of detail that Ms. LaRock has discussed for the house-by-house evaluation, particularly of low-income customers?
You'd have to direct me to where she states that.
No, I'll direct you to, actually, I'll ask you about, at your own contract with the with Frontier that does that program. And you can tell me. Yeah, let me pull out the specific provisions. Does your agreement for the Energy Saver low income program require the provider to provide information in each monthly invoice, including the number of dwelling units treated, the demographic information for each unit, including the location and the meter number? Is that information that you get every month with your bill?
Not sure of the demographic, but all the other data.
And for each of the dwelling units, do you receive a list of measures installed?
Yes, we do.
And with those list of measures, are there energy savings and estimates for the energy savings?
Not estimates. I mean, so this, I think what you're asking, if I may, you're asking of the energy savings for the measures. Is that what you're asking?
Mm-hmm. Yeah.
So
When they report the measures, do you also get energy savings as part of the report?
Yes, we do.
And so what is this extra information that you're saying that the city would have to pay for to get from EPE?
So if you recall from the last case, the city, and I guess I take that back. I think throughout Lisa's testimony, as I state in my rebuttal testimony, let me see if you give me a second here. Yes, as I state on my question on my rebuttal testimony, page 22, line 13. In each of those bullets, she's asking for additional information that we could report on to benefit the city's sustainability office initiatives that are not required from El Paso Electric.
I'm looking at page lines 12 through 14.
Page what?
Page lines on page 24, lines 12 through 14. And you're pointing out a simple report on a number of measured units supplied and kilowatt hours saved limits our understanding. And then she says that the demographics, what information do you think she's asking for here that isn't within the information that you are currently getting from your contractor?
If you give me a second, let me refer to her, let me go back to her testimony. I think, so on this one, I guess I should have started from line 4 on hers, and I'm not sure why I didn't. Let me see. Because yeah, on lines 4. So I'm looking at Lisa's direct testimony, Lisa LaRock's direct testimony, page 19, starting on line 4. She's asking for our programs to be more rigorous, designed to address the barriers to participation, installation, sharing further.
Sorry,
I'm sorry, Mr. Lee. Lisa's statement on her direct testimony on line 4, she states, what seems to be missing is a more rigorous program design to address the barriers to participation, installation, information sharing, and further pursuit of EELM programs. These are precursors and amplifiers in the plan that might otherwise increase adoption rates. Community-based social marketing disaggregates all the steps to determine impediments to successful dissemination and adoption practices. And so I took that a simple report on number of measures, units supplied, and KW saved. I mean, that is something that we're already doing, but it was the items above that statement that she's asking for.
It was the items of what?
Lines 4 through 8.
Oh,
that,
okay.
You know,
that's not a reporting requirement. That's not a reporting requirement. That's a program design question, right? I was trying to talk about reporting requirements.
So what's the question?
So the question is, again, did Ms. LaRock request any specific information as a reporting requirement that the company isn't already getting on a monthly basis pursuant to its agreement with the contractor?
I'm sorry, are you, can you please repeat your question, Ms. Stephen?
As far as reporting requirements, not program design and not outreach, but as far as reporting requirements, did the city, did Ms. LaRock ask for anything in her testimony that the company isn't already getting as part of this program that you suggest the city would have to pay for because it's more than what you've got?
Ms. Stevens, I apologize for interrupting. I'm having a little bit of a difficulty following you. Are you talking about proposed reporting requirements that are proposed by Ms. LaRock, or what are you referring to by reporting requirements?
We're talking about reporting requirements that are proposed by Ms. LaRock because Ms. Brea's testimony said that the city is asking for gathering data that would cost more.
Okay, I appreciate that clarification. I was confused by use of the term requirement, but you're talking about proposed reporting by the city, not an actual requirement as it exists today.
Right. And Ms. Olson, your video is getting kind of weird. I think
coming in the window.
It's just light. I thought you were sort of, you're blurring. So I hope that you're still online with us. Okay, so so Ms. Perea, let's one more time. Let's just look at CLC 19. That's the 2020 plan year annual report. And oh my goodness, too many things open. Sorry, I've lost too many open myself.
I'm sorry, what exhibit are you referring to?
CLC 19.
All right, thank you.
And I hope not, it says 19. I'll get there somewhere. Okay, yeah, here it is. So I'm on page 7 of the report, page 10 of the PDF. You with me?
Page 7 of the report?
Yeah.
Yes.
And there's a table 5 at the top?
Yes, that's correct.
Okay. Now, and this 2020 New Mexico Energy Saver Program summary, does this reflect that an aggregation of that information that you're getting on a monthly basis?
Yes, it does.
And would it be impossible for the company to share more information?
That would be up to the commission, right? We currently report on the energy savings and on the tracking requirements that are required of us. Nothing more.
Okay, thank you. And that's it, believe it or not. Thank you so much, Ms. Freya and Ms. Olson and Mr.
You're
Lennon.
Thank you, Ms. Stevens. And let's move on. Who would like to cross-examine next? I'll just ask. Okay. Ms. Lynch, are you ready to go? It's all yours. Please identify yourself and then you can begin for the transcript.
Good afternoon, Mrs. Perea. My name's Kara Lynch, and I'm the attorney for CCAE.
Yes, good afternoon.
It's nice to meet you.
Nice to meet you.
Thank you. I just have about 10 questions. Many of them I think we'll be able to fly through. I just wanted to get a sense from you. In your opinion, do you believe that the plan that EPE submitted will contribute to lower greenhouse gas emissions for New Mexico?
Yes, I do.
And is that in the public interest from your opinion?
Yes, it is.
Okay. Could you find your rebuttal testimony, please?
Yes, I have it with me.
Okay. And just if you could turn to page 13.
Okay.
Okay. And there, you state that EPE will consider and evaluate the recommendation of CCAE. And throughout your rebuttal testimony, you use that phrase, consider and evaluate certain recommendations. What do you mean by consider and evaluate?
Well, first that we will actually evaluate it is the consider part. I guess that's one of the same, right? Consider and evaluate it. We will consider to evaluate it and look at what the possibilities are of trying to get to that increased proposed incentive amount of $1,000 and double the incentives.
Thank you. That's helpful, and I'm glad those are one and the same. What sort of timeline exists for EPE to consider and evaluate the recommendations that EPE agreed to?
Well, I think that what kind of timeline, it all depends, I guess, on this hearing, like what the timeline is and going forward. This is pretty hard time right now because the evaluator is working on closing out our 2021 program. But to answer your question, probably like would be safe to say maybe like June timeframe, June, July timeframe to get.
Oh, that's great.
But that's after, because we have our filing to do as well, right? This is our filing season in Texas and New Mexico.
Yeah, it's just helpful to get a sense for when you'll start that evaluation. So next, will EPE communicate the results of its consideration and evaluation of recommendations that you agreed to?
To
stakeholders?
Yes, most definitely.
And how will you communicate these results to stakeholders?
I would imagine we could do it something like what we did with the public advisory meetings to everybody that is interested, from that service list.
Okay. So you like the service list for this hearing, is that?
Yes.
Okay, so you'll just communicate maybe when you're going to start your evaluation and when you get the results.
Yes.
Okay.
Yes, we could do that.
And when can we expect EPE to implement the agreed upon recommendations?
That would be something that would be able to happen right away. I mean, because we're working with the evaluator, and that would be something that would kick in right away, I would imagine. Right after
You
this.
mean upon approval of this plan?
Yes.
Okay, thanks. I'm now going to transition to the lighting program. Ms. Stevens had briefly spent some time on the issues involving the lighting plan. Regarding the lighting program, are there any commitments to that program that EPE might be discussing internally?
I'm sorry, are you referring to the residential lighting program?
Yes.
Like we would be, I'm sorry, can you rephrase your question or ask your question?
I think I'm just trying to understand whether internally to EPE, whether you have any discussions occurring about the residential lighting program.
No, we don't.
Okay. Considering the changes at the DOE and possible implementations of a new rule, would EPE be open to having a meeting with stakeholders about your lighting program towards the end of 2022 to take into consideration any policy changes that might affect that program?
Yes, we would be interested in that. I mean, if you're asking if we get input from CCAE and yes, most definitely.
Okay, that's great. Hearing examiner and Mrs. Padilla, that concludes my cross-examination.
Thank you, Ms. Lynch. Mr. Black, you have any questions?
No, Your Honor, we have no questions of this witness, and we thank her for her participation in this proceeding.
Thank you.
Thank you, Mr. Black. Mr. Simpson, do you have any questions?
Yes, sir, I do.
Please.
Good afternoon, Ms. Perea.
Good afternoon, Mr. Simpson.
Thank you for your endurance.
You're welcome. My pleasure.
I do have just a couple of questions. I wanted to follow up on one of Ms. Stevens' questions because I didn't quite understand your answer. So I guess I'll refer you to your rebuttal testimony, page 5, and I will go there as well. So I'm sorry, it's at page 6, the top of page 6, where you say the latest rule changes brought the rule into alignment with the EUEA. Ms. Stevens asked you about this, but are you referring to the October 26 changes to 17.7.2.8?
Yes.
I guess I did not see where that rule was brought into alignment with the EUEA. Can you explain what you meant by this sentence?
Objection, hearing examiner Lennon. Ms. Stevens has already asked this question and she's already answered what she meant by that statement. And Mr. Simpson disagrees with it, but the question's been asked and answered.
Yeah, but that was from a different party, and I really don't know where Mr. Simpson is going. He may have some other method of cross-examination. So he may be asking it for a completely different reason. I'm going to let him answer overruled. So you can answer the question, ma'am.
Let's see. Okay, give me a second. So I'm not sure if I'm able to reference one of the exhibits that CLC brought in.
You can, especially if it's an exhibit. Well, you can reference it either way. So go ahead.
All right, so I'm looking at CLC Exhibit 28.
Okay. CLC 28.
But it's hard to make, I don't have the EUEA rule, but so, is my understanding, the rule changes that were brought up, that were made in the rule align more with the EUEA in its definitions of like energy efficiency, and okay, let's see here. And I want to say in section J, where it states public utility shall demonstrate that its portfolio of programs, measures, and programs are cost effective, meets the utility cost test as defined by subsection C of section 62-17-4. And are designed to provide every affected customer class with the opportunity to participate.
I'm sorry, and are designed to provide.
Every affected customer class with the opportunity to participate and benefit economically. So the language in both the rule and the EUEA are aligned with each other.
I'm sorry, did you say they are aligned with each other?
Yes.
Okay, thank you. I appreciate that answer. Okay, so I do have another question or two. Let me refer you back to your direct testimony, page 32.
Okay, I'm there.
I'm almost there. Okay, so I'm looking at line 17 to 20, and you're talking about some of the sweep recommendations for air source heat pumps and heat pump, or I'm sorry, heat pump water heater. Do you see that?
Yes, I do.
So I guess first question, what does income qualified program refer to?
That is our low income program, for our program for low income customers.
Okay, and is that what you also call Energy Saver and Energy Smart? Are those the two components?
Those are the two programs where those that income qualified customer would be eligible for.
Okay. So can you, are you able to point to where those additional measures have been added to your program?
In the low income or?
Yes, where heat pumps or heat pump water heaters have been added
Well, so that will
to your low
follow.
income program?
I'm sorry, sir.
I'm sorry, I was just clarifying, added to your low income program.
Well, so those measures will be added in the Energy Smart program, which will be, if approved, would be administered by MFA.
Okay, can I refer you to EEPE Exhibit 3? Page 52.
Oh, I think you mean ADM 1?
Yes,
ADM-1?
yes, yeah, it's also labeled EPE 3, I think, and it's page 52 of 92. Do you have that?
No, I don't think so. All right, I'm almost there. I'm sorry. So what is that EPE?
Yeah, it's EPE Exhibit 3, which is also ADM 1, and page 52 of 92.
Yes.
And about the third line of the text under program overview and goals, it talks about a variety of energy efficiency measures.
I'm not there yet. Just a second, please.
Okay.
All right. Okay. Yes, I'm there. Page 52 of 92.
Right. So about the third line of the paragraph, it says a variety of energy efficiency measures are offered at no cost, including insulation, LEDs, duct sealing, air infiltration reduction, and other measures.
LEDs. Slow down.
LEDs. Okay. LEDs, duct sealing, air infiltration reduction, and other measures. But I don't see heat pumps or heat pump water heaters here. And I'm just wondering, I guess why not?
Oh, well, they're under the other measures deemed eligible. They are in the TRM. Oh, I take that back. I think they're in the. I'd have to look. Let me see, just because I know.
If you go to the next page or two, table 46 and table 47.
Yeah, they might be from another. Go ahead.
They're not listed, and well, I would ask you if you see them listed there anywhere in table 46 or 47.
I think this was one that we recognized in our in discovery that we left out inadvertently. We left that out of these tables.
Okay, I guess I did not notice that in discovery. Can you point me where I might find that?
I don't know. I mean, we had over 200 and close to 280 questions, so I wouldn't know where exactly to point that out. It'd take us some time to find it. But I think it was through discovery, or we realized it ourselves. But I think, I'm not sure.
Well, it's part
Okay.
of Ms. Martin's testimony. Excuse me. Do you know if Ms. Martin will be correcting those charts when she does corrections to her testimony tomorrow?
Are you asking?
I'll ask
Right.
counsel. Ms. Olson, do you know?
I don't believe she's correcting those exhibits, but if Mr. Simpson wants to ask Ms. Perea if they're intending to include those measures, I think he can ask that.
Okay, I was going to say he could also ask Ms. Martin, but go ahead, Mr. Simpson.
Yes, I would like to ask you, Ms. Perea, if you plan to include those measures, that the heat pumps or heat pump water heaters, and it could be either in this program or Measure Energy Saver, or I would just it might also fit in Energy Smart, because that talks, if you want to go to page 60, this program, about the 5th line, it says help pay for deeper retrofits, which seems to fit.
Yes, Mr. Simpson, we will be offering these, and I think we mentioned that they'll be part of our Energy Star New Homes program as well. So it'll be across all our residential customers, programs, to answer your question. And but yeah, and I know that we did, yeah, we inadvertently missed it, but it will be part of our offerings in our programs, in our residential programs, as we had stated to CCAE.
Okay, I appreciate that, and that's good news. And related to that, let's go to your direct testimony. This is my last question. Going to your direct testimony, page 33. Line 3 to 6. And here we're talking about incentives for Energy Star heat pump water heaters. And this is not in the low income programs, but rather in a different program. But you're proposing inclusion of the recommendation, but not at the incentive range as suggested by SWEEP. And so a couple of questions related to that. Would eliminating the free ridership allow a higher cost effective and higher incentive that would still be cost effective?
That would be a question for Amy, and I'm not sure that no, but those free riderships are provided to us by the EMV evaluator. That's not up to us to decide what that free ridership should be.
Okay, I will ask Ms. Martin tomorrow. Assume that'll be tomorrow. So last question, because I think this is more of a decision that El Paso Electric might be part of. If not every measure needs to be cost effective, could Mr. Brandt's recommended $1,000 incentive for heat pump water heaters be implemented while maintaining a UCT of greater than 1 at either the program or portfolio level?
That would depend on the program. I mean, the different program. I mean, that's a.
I'm sorry, what was the last part?
That would depend on the program. I don't know the answer. It would depend on the program.
Okay, so you're saying just sort of depends on the math.
Yes. I believe that's the case. I'd have to think it through a little bit more, but of all the variables that go into that.
Okay, thank you. That's all the questions I have.
Thank you, Mr. Simpson. I think we did cross with all the parties. Ms. Olson, you can have an opportunity to rehabilitate. I want to mention one thing. We're now 2 hours into testimony. I mean, cross-examination without a break. I'd like to close by 5 just because state employees like to go home at 5, and I respect that. And that gives us about 40 more minutes. We could take a 10-minute break because we've been going for 2 hours and come back and do your rehabilitation. But if you think it's really short, we'll just push right through it. What would you like to do, Ms. Olson?
Mr. Hearing Examiner, I would ask that I could just do it quickly so Ms. Pereira can be excused. I have probably 2 questions.
Okay, go ahead, Ms. Olson.
Ms. Pereira, there seemed to be a little bit of confusion about incentive values or regarding incentive values for a measure. And more specifically, I think you were asked certain questions about incentive values used for purposes of determining cost effectiveness. And then I think you were also asked about the final incentive rate for a measure. Does EPE ultimately decide the final incentive rate for a measure?
Yes, we do.
And is that necessarily the same incentive rate that was used for purposes of determining cost effectiveness?
No, it's not.
And Ms. Martin is the witness that testifies to the cost effectiveness determinations, is that correct?
Yes, that's correct.
And so would Ms. Martin be the appropriate witness to testify to the incentive values that were used for purposes of determining cost effectiveness?
Yes, she would.
Okay, thank you. Hearing Examiner Lennon, I have no other questions.
Okay, thank you, Ms. Olson. I don't believe there's any recross based on that short re-examination. Ms. Stevens, do you have?
I do.
Within
I
the
do
scope,
have
of
one.
course.
I think it's one question.
Within the scope, please.
Yeah. So thank you, Ms. Pereira. If your testimony is that EPE ultimately decides the customer incentives after on which may be different from what was presented in the filing. My question to you is, how does the commission know what programs are being offered if it doesn't have this sort of information? I mean, for example, if somebody comes to the commission complaining that they were treated unfairly by the company, how's the commission going to deal with that if they don't know what the incentives are?
Ms. Stevens, you initially used the word program and then you finished with measures. So
I'm sorry, just program
question.
Call it program, although I guess a complaining customer might be a full program, might be a measure, but
Hearing Examiner Lennon, my question was specific to incentive rates for a measure.
Yeah, I follow that. But not the same rate for cost effectiveness. So we can only, within the scope, we should deal with the incentive rate for measures.
I'm delighted to hear information about measures.
Sustained. Go ahead, tell her, Ms. Pereira, if you know.
And so the question, if you could please repeat the question, Ms.
The question is, if the incentive, the customer incentive levels for measures are not predetermined in this hearing, how does the commission know when a customer comes and says, I was treated unfairly, or I didn't get the same? How does the commission know what the plan is, that it's just approved so that it can do its function as the regulating implementer or the regulator?
So he still went back to measures, but so just take it as a program, and the programs are not going to change. It will have the programs that the commission approves that we will go forward with. If we have a customer complaint, the commissioners, I mean, we don't get any complaints, but I guess I'm not sure. It all depends what kind of complaint you're talking about. I mean, that's kind of vague question. I don't know how to answer that, what you're asking for. I mean, because it's going to be the programs that we're offering, and the measures are all eligible measures from the TRM. I mean, so I'm not sure what your question is.
Ms. Olson's questions were about the incentives related to specific measures, not the programs. And I just wonder if those change, if the company has the discretion to change those based on, other than what we see in Exhibit A DM1, the plan, what then is the program? What then, you know, if a customer comes with a complaint, what is the commission going to base its decision on if it doesn't know, if there's no definitive description of what customers are entitled to?
So on our website, we have definitive incentive rates that for each measure, and those are communicated to the commission in our annual reports. You know, the links are there and the information is there, and along with the forms, the brochures, the rebate forms, it's all laid out once those are put in place.
How frequently does that happen?
As on a timely, as soon as possible. I mean, we're they're on our website. We try to keep our website up to date.
No, what I mean is, do you put that stuff up on the website, and because this is a 3-year plan, it's good for 3 years?
Didn't you just say it's in the annual report to the commission?
Yes,
So
yes, I
that's the
did.
answer, I think. It's retroactive for the report year being filed. So you can see what has happened during the previous year. I mean, the complaint wouldn't be about the future, it would be about the past. And
well, the complaint would be about, if the complaint happens in June and the report doesn't come till the following July, there's, you know, what happens if a complaint comes in June based on something on the company's website, and the company doesn't report this information till the following June or July? Where does that leave the customer and the commission?
Ms. Stevens, I'm not going to, like I said, ask your questions, but and I don't know exactly how it works, but I know there are personnel here at the PRC who answer the phones when those inquiries are made concerning what they believe has been some sort of wrongdoing by a utility. And I think the investigators, for lack of a better title, would pick up the phone and call the utility. And it's really as simple as that.
Was that your answer or hers?
I'm just trying to give perhaps you an understanding, not trying to protect this witness, but you're asking this witness how the PRC is going to handle a complaint. And really, this witness may not have any idea of how the PRC handles complaints.
Okay. I'll stop there. Thank you, Ms. Perea.
Thank you. You're welcome. Thank you, hearing examiner.
Okay, so since there's been recross, I guess there could be redirect within the scope of the recross. Do you have any question about that, Ms. Olson?
Hearing examiner Lennon, I don't. I ask that Ms. Perea be excused.
Thank you. I appreciate that. I believe that concludes Ms. Perea, and I'm not about to start the next witness at 4:27 p.m. Having been recently experienced in how long it takes for the cross-examination of this EP witnesses to happen. So I'll ask first, unless there's some reason to not excuse Ms. Perea, I'm going to excuse her for the day. Any objection to that? No. Well, thank you again, Ms. Perea. Let me thank you for being here. And it's been a tough afternoon and a lot of questions, and you've been very patient and very understanding with all the questions. So thank you, and you're excused. Thank you. Your lawyer might want you to stay. I can't speak for what she wants. Ms. Olson, since we've concluded with this witness, I would take a break right now, but it's 4:28, and I just think we should just break for the day. It's been a tough afternoon, and we'll start again tomorrow morning at 10. Is that okay with you, Ms. Olson?
Hearing Examiner Lennon, it's fine with me. I'm a little bit concerned with how slow I think.
Well, me too, actually.
3.5 hours of cross-examination is concerning when we have 2 more witnesses and we would like the opportunity for cross-examination of other witnesses. I don't know if it would add any benefit to just move through admitting Ms. Martin's testimony so that she can immediately start on cross-examination in the morning. But I'm also happy to break. I defer to you and the court reporter.
I don't like to break up a witness halfway through. I mean, how do I know? He could have a car accident in the morning and we couldn't complete his testimony. And that's even weirder. And, you know, the admission of the direct testimony really only takes 10 minutes or so. So I really don't see the benefit, and there's a potential adverse situation. I'm not going to agree with you on that unless someone else insists. So I still think we should break for the day. Like I said, it's been kind of a difficult day, even though we took an hour lunch break. I just don't want to start the next witness. But thank you for the very kind and very thoughtful suggestion. Does anyone else have any position on that? Does anyone else want to start in the next witness at 4:30 in the afternoon or so? So no one's bobbing their head yes and yes. I work with you guys. You know, I don't like to direct. I like to collaborate with you. All right. So I think that's about where we are. Does anyone else have any other comments you want to make? The only thing I could think of would be to start at 9 instead of 10 in the morning. The problem with that is the notice on the PRC website. I haven't looked at it, but it usually will say 10 if I've scheduled it for 10. And the public has a right to tune in. So for that reason, since they've been notified that it starts at 10, I'd rather leave it at 10. So if you have no strong objection on that, I'll just leave it at 10 and we'll start at 10 in the morning. Does anybody have any reason we should get together for any type of meeting in the morning, off the record? I don't think there is any need for another off the record meeting.
Well, sorry to cut you off.
Sure, go ahead.
But I am concerned about how many witnesses we have to get through tomorrow. And I don't know if we want to spend time before the hearing, possibly divvying up minutes or having parties come together knowing that we only have, 7 hours.
Right.
How can we equitably split those 7 hours?
Well, your cross wasn't very long, and I sincerely appreciate that. Ms. Stevens, there's no secret that your cross was damn long.
Well, I think that since Mr. Ray answered so many questions, I'm thinking that I have maybe 45 minutes with Ms. Martin, depending, of course, on her answers, and much less with Mr. Hernandez.
Well, actually, you just asked some really long questions, to be honest with you. And I would ask that you keep in mind all the rest of the lawyers. We know we're burning a lot of lawyer time here. I don't know, I could count them up, but I like to have a concept of like man hours, we have lawyer hours. And, like I said, you're going to be cross-examined, and I take it Miss Martin and the other Mr. Hernandez, I think it was. If you could just keep all of us in mind when you ask your questions, to keep them as short as possible and get to the information you need. It might move the whole day along if you could keep your questions a little bit shorter. Ms. Lynch, I think these hearings take as long as these hearings take. I don't want to infringe upon anybody's rights to have a complete and full cross-examination. I don't want to create that reversible error before the judiciary by cutting off anybody's cross-examination. And that's the way I see these cases. If necessary, we're going to go to another day, to a third day. And I hate to even think this, but maybe even to a fourth day. And if that's what it takes, that's really what it takes. It's better that I allow everybody to do their case the way they want to do their case. And that's just the way I do these cases. Like I said, I appreciate you keeping yours nice and short. And I would appreciate everyone, including Ms. Stevens, to keep their case as short as possible for tomorrow. The reason I say, not go for another half hour is that it was a tough day, frankly. And I can feel the wear and tear on all of us. And I want it to be productive time, and starting testimony for half an hour and then breaking it is probably not the most productive way. But thank you, Ms. Kara. I welcome any other comments, because like I said, I like to do this collaboratively. Ms. Stevens, do you have an opinion or any comments?
No.
Okay. Mr. Black, are you ready to complete for the day and then start at 10 a.m. tomorrow morning and roll through this?
I am.
Okay, Mr. Simpson, can you join us again at 10 a.m.?
Yes, sir. I'll be here.
All right, Mr. Dunn, you're welcome to stay. I don't think you're required until you testify. And same for Miss LaRock. I hope I said that correctly. Mr. Lee, do you have any comments or anything that could help us? I apologize for not breaking an hour ago, but anything else?
No, sir.
All right, then I think we will adjourn for the day to reconvene tomorrow at 10 a.m. Thank you, everyone.
Thank you.
Thank
you,
you.
Examiner.
Thank you.